Okay, good morning everyone. Inquiry's resumed. I'll just check for any housekeeping matters before we start in earnest.
Yes, so I've got a couple, sir. So the first one is just to let you know that you may have already seen this, but in the core documents now, in CD15, we have all of the documents that have so far come into the inquiry in order. So it's effectively the opening speeches, a number of written speeches from third parties, and the site visit itinerary are all in there and numbered, just so everyone knows that that's there. So secondly, on the site visit which we discussed yesterday, obviously you're now going in half term, which my learning friend asked you to do, which is absolutely fine. But so if you do that, we would ask on that same day for you to also visit Enderby. I mean, obviously, given the issues that arise between comparison, they are very close, as you know.
Yes.
And again, in terms of whether you want any guide on that, I mean, really, I don't think it's necessary for us to give you any detail about what to look at there. You have got in our golf proof some aerial Google photos of, I think this is Mr. Smith's main proof. He puts in, yes, on pages 23 and 20, 20, yes, that's right. Hang on. So which pages did you start?
Paper 23, yeah.
Yes, that's right, yeah. So, I mean, so obviously that gives you a sense of what's there.
Yeah.
So really it's to see, I think the main thing to see is probably the golf course, but also to notice the other facilities that are around. But if you're happy with that, if you want a more detailed guide of what you should do, we're happy to provide that, but I don't think it's necessary.
No, I'm very happy to do that, and I'll do so. And my thanks for the team that put together the inquiry documents. So thank you for the trouble.
Thank you.
Thank you. Okay.
That's all. So that's all from me. Thank you.
Okay. Thank you, Mr. Robson. Okay. Well, let's begin in earnest then. And your last witness, Mr. Robson.
Yes. Thank you, sir. Mr. Baker-Adams, from your proof of evidence, please, to introduce you. You are Glenn Baker-Adams. You're the Development Services and Enforcement Manager within the Planning Service at Blaby District Council. You've 14 years' experience in town planning and have been employed by Blaby since October the 1st, 2025. And prior to this, you've held many senior planning roles at both local authority and in the private sector.
That's correct.
In terms of qualifications, you have a Bachelor of Science degree in Planning and Development and a Master's degree in Planning and Natural Environments from Birmingham City University, and you are a licentiate member of the RTPI since August 2012, with a view to becoming fully accredited by the end of the year. And that's correct?
That is correct.
And then at 1.4, you say the evidence which you've prepared and provide for the appeal in this proof of evidence is true to the best of your knowledge, and has been prepared and is given in accordance with the RTPI Code of Professional Conduct, and you confirm that the opinions expressed are your true and professional ones.
Correct.
Thank you. Right. Firstly, as you've set out in your proof, and in fairness as Mr. Cusson does in his, for the purposes of assessing harm to the green wedge and the golf evidence, you rely on that of Mr. Wright and Mr. Collins, and that's correct?
That is correct.
Right. So let's just jump into policy then, please. And let's start with CS 16, which is CD 6.11. Firstly, with regard to the green wedge reason for refusal, this is the main policy that we're focused on. Correct?
Correct.
I'm leading as points of disagreement. I don't think as points of agreement. I don't think there's any issue. We've spent some time already in the functions of the green wedge, and that's set out in the 4 bullet points at the top. And then further guidance is given in supporting text 7.16.2. You see that?
Yeah.
Primary functions are to prevent coalescence of distinct settlements and provide potential as an important recreation resource in areas that are often mainly built up. Therefore, as a planner, when you come to interpret and apply this policy, what is it that you say the inspector should be looking for?
So the starting point would be to ensure that any development meets the 4 aims within the policy. So preventing the merging of settlements, ensuring that it guides development form, provides a green along to urban areas, and provides that recreational resource.
And then with regard to the specific tests, at the end of the policy, land use or development should retain the open and undeveloped character of the green wedge. Your understanding as a planner of what is meant there by open and undeveloped character?
I would imagine the land to be undeveloped with no form of buildings on the site.
And in terms of openness, is this a landscape and visual consideration, or is this a spatial consideration in line with the policy?
This would be a spatial consideration.
Looking again at the wordings of the test in B, retain and create, what do you understand is required for development in terms of retention and creating green networks?
So retain, again, it'd be maintaining the green networks that are already on the site, or the creation of new ones, either through footpaths or any sort of link between the countryside and open areas, open rural urban areas.
So moving to the second part of that sentence, that any creation of green networks or retention of them must be for those between the countryside and open spaces within the urban areas. So when you're looking at what is being retained and created, what does the policy tell you to focus on? To where they need to be connecting?
Yeah, to connect into those networks.
And again, we see in C, retain and enhance public access to the green wedge. So when you come to look at what is there currently and what is being provided, what do you understand is meant by enhancement of public access?
Making it better.
Thank you. I'd like just to go to the Statement of Common Ground, please, CD 5.3.
Yeah.
And if you've got paragraph 8.25, please, which is on page 25 on paper, page 27 on the PDF.
Yeah.
Do you have that?
I do have that open.
Let's wait for a moment, please. In paper copy, sir, it's page 25. And you see there, paragraph 8.25 under the heading Scheme Disbenefits. It is agreed that the following disbenefits are attributable to the development scheme. First bullet point, development proposals will result in harm to the function of the green wedge. Do you see that? So,
I do see that, yeah.
so the disagreement then is presumably the extent of that harm.
Indeed, yeah.
Thank you. I want, before we look at how you've assessed the level of that harm, I want to look briefly at how Mr. Cussons has done it. If you go to his proof, please.
Yeah.
After the musical interlude. And if, while we're listening to the ice cream van, if you could turn to paper 35, PDF 39.
Yep.
Sorry, no, I've sent you to the wrong place. It's paper 33, PDF 37.
Yep.
And one of the metrics that Mr. Cusson is using is about measuring the distance between the opposing boundaries of the green wedge and how that would be affected by proposed development within that green wedge area. What's your response to this approach as a means of measuring harm?
I find there is more to it than just these measurements. I think Mr. Collins has referenced quite a few things that have demonstrated that there are other matters that one needs to assess when they're assessing this impact.
In terms of the points you rely on from Mr. Collins, just going back to your proof, looking at 2.7, 2.6 and 2.7. What are those key points that you as the planner applying the policies have taken from Mr Collins to assess the level of harm?
As per my proof, when the development will erode this residual gap between the existing and anticipated southern edge of Blaby and merging the settlement with the business park into the settlement edge, this residual gap, physical or otherwise, would be materially reduced, such as that gap would be defined by the A426 corridor.
So, in terms then of looking at harm, should one look at measuring distance as Mr Cusson has set out, or recalling spatial policy with the priority of preventing the merging of settlements? Should one prefer the approaches you set out and Mr Collins sets out here?
I would agree with mine and Mr Collins' approach, please.
Right, I want then to just look at the emerging allocation very briefly in Mr Cusson's proof,
Yeah.
which is at so it's the rebuttal proof, forgive me.
Okay.
So it's on page 6 of the paper version, page 7 of the PDF version.
Yeah, got that.
Which is part of excerpts you see from the local plan proposals map, and then the master plan shown just above.
Yeah, I can see that.
What stage is the local plan at currently?
We are seeking to build up to a VEG 19 stage.
And therefore, in terms of plan preparation, what stages are left?
Very early stages, so we still need to go through a series of public engagement, public consultation, examination.
So in terms of the weight that can be given to the potential emerging allocation that's not yet in a Reg 19 published local plan draft, what weight do you say?
Sorry, very limited weight.
Thank you. So then going back to the policy tests in CS16, so CD 6.11. And the 3 tests at the end of the policy that land use or development in green wedges should retain the open and undeveloped character of the green wedge. Your view on whether this scheme does that, please?
The scheme fails to do that. The evidence given by Mr Collins, I think, clearly sets out that the development wouldn't retain the open and undeveloped character of the green wedge.
And retaining and creating, so by creating I'm going to add in an implied word, new, creating new green networks between the countryside and open spaces within the urban areas. Are any new footpath links from the countryside into the open spaces within the urban areas being proposed?
No.
And if we look at Mr Holliday's proof, the appendices, there is a plan, electronic, page 21, accessible green space and linkages with the appeal scheme in place. Do you have that?
Just loading it now, bear with me.
Yeah, no problem.
Thank you. What page, please?
It is electronic, page 21. The plan title is Accessible Green Space and Linkages with Appeal Scheme in Place, figure 18.
Forgive me.
No, don't worry.
Yeah. We'll open it again. document reference again, please? I might have opened the wrong one.
Oh, okay. I'm not working off the core documents for those appendices. Bear with me. It is 14.5.
Electronic page
21.
21. Thank you. Yep, I'm on that page now.
Right, you've got it.
Yep.
So, recalling that the policy test is retain and create new green networks between the countryside and open spaces with the urban areas. So looking at that plan, you can see the yellow dotted lines are existing footpaths, and the grey dotted line are potential new footpath links. Do you see those?
I do, yes.
So first, a preliminary point. Perfectly properly put yesterday by my learned friend, even if this scheme was granted, in policy terms, the site would still remain in the green wedge until it's taken out of the green wedge. Do you agree with that?
I do agree with that, yeah.
And therefore, connecting into the urban area from the countryside, is there anything new that's being proposed that takes a walker from the urban area out into the countryside that isn't already there?
Not that I can see on the plan.
So notwithstanding those new greyed out, dark grey, black, whatever colour they are, routes within the site, are they sufficient or not to meet the policy test in CS 16 and retaining and creating new green networks between the countryside and open spaces within the urban areas?
In my professional opinion, no, they wouldn't.
Thank you. The next test is, it's probably helpful to keep that plan open, and if you're struggling to open documents, could you start looking for the survey of footpath uses in Mr. Cusson's appendices? So if you need a core doc reference, it is 14.8.
I have 14.8 open.
Thank you. And then it is PDF page 141.
Can I have the electronic reference, please? Sorry.
Yeah, 143. Well, 141 is where it starts, and it says Appendix 13, Pell-Frischman Summary of Pedestrian Survey. And then the detail is a couple of pages down.
Yep, I have that open now.
And the results, as Mr. Cusson sets out, and as you can see on electronic page 14, well, let's look at the sites first. So first page, page 2 of the document, you can see where the surveys were taken, which was the access point to the footpath on Lutterworth Road, the exit at footpath Z67/1.2 onto Winchester, and point 3 is if you've crossed and gone down through the golf course.
Yeah, I can see that.
You see that? No other survey points, so far as you know, are set out. Good. The results over the page show that Site 1 and Site 2, relatively well used, 116, 120 two-way movements daily, and Site 3, 23 movements daily. And one of the points made by Mr. Cusson is that people probably don't use point 3 very much because it's through a golf course. Would you agree or disagree with that?
I think that's a fair assessment, yeah.
But 1 and 2 certainly do seem to be relatively well used. One of the further points made by the appellant is that with the improvement of going through the proposed public open space, point 3 would become a more used route. What's your view of whether that proposition stands?
The data would need to be supported to prove that fact.
But if it's hard because you can't get the data for something that's not there. Given the location of the public open space relative both to the urban area of Blaby and the proposal itself and the existing footpaths, what's your view of the appellant's position that point 3 would become a more popular route once the public open space is in place?
It would depend on that open space. That open space needs to be accessible for people to use.
And in terms of the distances people would need to cover, what's your position on whether it is accessible?
I think it's too far. I think the location of that, it would again be a benefit maybe to those who would occupy their houses and not have that overarching benefit that green wedges have.
One of the further points made by the appellant, and this is probably easier to see on Mr. Holliday's proof, his figure 18 that we looked at a moment ago. Do you recall that with the dotted yellow lines and the grey lines?
Yeah.
Is that once the public open space this scheme promotes is in place, once you have a more attractive route through this part of Blaby, it opens up the link into the Countersthorpe Country Park. You see that where that is?
Yes, I see that, yeah.
Is there any data from the appellant currently before the inquiry that shows how many people are currently walking that route down to Countersthorpe?
No, I've not seen that data.
And so there is currently a route to Countersthorpe Country Park from Blaby, isn't there, from the Z's 56.4, 1, 5 and then on to 44.2.
Yeah.
So we've no evidence and no baseline of how many people are currently walking it.
Okay.
So what's your assessment then of whether there would be any change, if at all, of those accessing the country park just because the public open space is produced?
I doubt there would be much change.
So when we then go back to the policy tests, CS16C, retain and enhance public access to the green wedge, especially for recreation. What's your view in terms of what's being proposed and whether it would retain and enhance that public access to the green wedge?
I maintain as per the proof that I don't think the development would do that or meet that test.
Why?
Due to that failed link not being provided as per the requirements of that policy.
But the appellant's position, which no doubt has to be put to you, is that people don't walk this way now because the golf course is there. Once we've made it attractive with our public open space, the numbers will increase and then they will continue to say, and then they'll be walking out further to the green wedge to Countersthorpe. Do you think the evidence is there to support that or not?
No, the evidence is lacking for that information, for that justification.
Right. So overall, as you've set out in your proof, conflicts with, and as you've set out orally, A, B and C, and the purposes. Now, of course, staying within CS16, there is that internal balance, isn't there? That you can see after F, the need to retain green wedges will be balanced against the need to provide new developments, including housing in the most sustainable locations. Firstly, there's no dispute that Blaby is a sustainable location.
No dispute.
The detailed boundaries of the existing green wedges will be formally reviewed through allocations and the DPD. So looking at that internal balance between housing and green wedge, what is your overall assessment of how that balance falls?
So, as per the proof, there is significant weight given to the provision of housing and affordable housing. However, the impacts that on the green wedge have been outlined by Mr. Collins are robustly supported. They've robustly put forward the case that the green wedge impacts will be significant enough to outweigh those benefits of housing and affordable housing.
Now, you reference a number of appeal decisions, of council decisions in your proof of evidence. Do you have that? So you set those out at 2.11 through 2.13, through to 2.13.
Yeah, I've got those.
I don't think we need to go into the details of all of those decisions, but what is the overarching point that you're making in terms of how one approaches this policy?
That the approach is traditional planning, in that every application should be treated on its own merits. Specific considerations need to be to each site and each characteristics of that development, and the impacts on that green wedge. And in each of these instances, it's been deemed to be, the level of acceptability has been deemed to be acceptable in accordance with the policies.
Because you accept, and you must do, and you do here, that the council has granted planning permissions in the green wedge for housing.
Correct.
And you rely on Mr Collins's evidence for your assessment of harm to the green wedge before you look at conflict with the policy.
Correct.
And you heard his evidence around it on day one, around the fundamental tipping point and the erosion of the gap. What importance does the fact that it reaches a fundamental tipping point in this location play in the decision making?
Significantly. That level of harm is deemed to be significant, and that erosion of the gap will, in my understanding, completely erode the policy, or the importance of that policy in terms of the impacts on the development on the site.
Thank you. Moving then to reason 2, and the loss of the recreational facilities, and it might assist you to have the MPPF up if you've got it in paragraph 104. If you want a core document number, it's 9.1.
Yep, that's open.
So looking at the wording of the policy, existing open space, sports and recreational buildings and land. And I just want to pause there for a moment to understand what it is that we are looking at. You heard yesterday in Mr Wright's evidence that the national governing body for golf recognises various formats of the game as the traditional formats, which doesn't include pitch and putt and crazy golf. Now, where the policy directs you to look at existing open space, sports and recreational buildings and land, where does crazy golf and pitch and putt fall within that policy?
They are still a sport.
And even if they weren't a sport, looking at the final of recreational buildings and land.
They are a placement.
Right. And I think there's probably agreement with us that sports includes the traditional formats of the game as recognised by the national governing body.
Indeed, yes.
Right. In terms of test A, about surplus to requirements, you rely there on the evidence of Mr Wright.
I do.
And so I want to look at B. Now, you accept that 104 is an or policy.
Yep.
So if the inspector were to agree with Mr Wright in terms of surplus to requirements, but to agree with the appellants in terms of replacement by equivalent or better provision, this policy would be passed. Good. So the appellant only needs to satisfy one of those tests.
Correct.
So I won't trouble you with 104A because of Mr Wright's evidence yesterday. You deal more with 104B. The loss resulting from the proposed development would be replaced by equivalent or better provisions in terms of quantity and quality in a suitable location. So firstly, the overarching approach to that. You've read the Maplethorpe decision. When one looks at quantity and quality and equivalent or better, how does one look at that? Is it looking at area, is it looking at type of sport, or is it an exercise of judgment?
It's very much an exercise of judgment against what's proposed.
So, at first, looking at what is lost, you rely on the evidence of Mr Wright.
I do, yeah.
And so you're looking at whether what is replaced is equivalent or better. And part of the appellant's case, firstly, this £1.8 million point. Do you have Mr Cusson's proof?
Just bring it back up. What page is that?
If you give me a moment. It's page 44 on the PDF, page 40 on paper. Pull up Mr Holiday got sacked at the start of this paragraph. I think Mr Cook, another landscape expert that Mr Cusson's used to using, that provides the evidence on, oh no, because he's got the landscape approval in the back, so Mr Cusson is right and I was wrong. I was chuckling away to myself, but no, I'll withdraw that, indeed. The 1.8 million comes at the end of that using the HACT tool, you see that?
Sorry, I'm still trying to locate it.
No, it's fine. Paragraph 5.66.
5.6, okay. Yep, I can see that now, thank you.
So the 1.8 million pound comes from the HACT tool, and you say in your proof that you're not disputing that figure.
No.
But what relevance does it have? How should the inspector approach it?
There are more factors, I guess, at play here in terms of the social and the other impacts that will be obtained from the development.
Well, the 1.8 million pounds relates to a calculation for the social value impact of the open space delivered by the scheme. Is there any assessment of the social value impact of the golf course?
On the appellant side, no.
And so when one is looking at equivalent or better, firstly, is this HACT toolkit determinative of whether it's equivalent or better or not?
No.
And secondly, does it allow you to assess what's equivalent or better if you don't have a baseline of?
No, it does not.
Thank you. Secondly, the offer or part of the case from the appellant is the 11v11 football pitch, which is proposed. And I'd like you to draw up the consultation response, please, from I can't find it myself now, which isn't helping you much.
Is it the sport and physical activity?
It is.
Yes, I have that open.
Glad you've got it open. No, thank you very much. That's right, 'cause it's health and leisure rather than... I've got it, thank you. So looking at this assessment, this is produced by the council when assessing the proposal.
Correct.
And it looks at the additional provision required. And the conclusion, if we can go please to the summary of suggestions, it is a 9v9 or 11v11 youth pitch provided on the development site.
Yeah.
What's the basis for the consultation response making this suggestion?
So this is a mitigation. So the development proposed would yield obviously certain residents, and the requirements for those people would be that requirement for that 9x11 or 9x9 or 11v11 youth pitch to be provided.
And so if that wasn't provided, what would be the consequence of, or how that would that be factored into the decision?
The development would not have the sufficient mitigation for the development proposed.
So therefore is the 11v11 equivalent or better replacement?
No, it would not.
5.68 of Mr Cusson's proof is a list of the other obligations, or some of the other obligations included in the section 106. 61 grand thereabouts to the 3G pitch at Holmes Park, 181,000 to the ancillary facilities at Oakfield Park to support with the pitch improvement, and 17,500 to the cricket provision in Blaby East. How do you relate these to whether they are replacements of equivalent or better?
Again, mitigation again.
And then the point where there's a dispute within the section 106, the inspector will have seen the blue pencil clause, relates to the £100,000 improvement to golfing facilities within the catchment area. And the council's position is that that's not SIL compliant.
Correct.
Why do you say that isn't SIL compliant?
It's not attached to anything. There's no specific basis about what that money will be spent on. So within that regards, we can't deem it to be SIL compliant.
Now, Now, even if the inspector were to disagree with you and conclude that it was still compliant, we know from Mr. Smith's evidence that the Enderby professional who works at the golf course and has worked at the golf course for a number of years thinks that it might cost around £250,000 to put adventure golf course at Enderby. So if £100,000 was granted or was still compliant, would that meet the requirement of delivering the adventure golf at Enderby?
No, it'd be markedly short.
So therefore, back to 104. The loss resulting from the proposed development would be replaced by equivalent or better provision in terms of quantity and quality in a suitable location. Your overall conclusion, please.
The proposed development would not provide this equivalent or better provision in terms of the quality and quantity of suitable.
Right, I want briefly to look at benefits, and I'm going to lead on this because it's points of agreement within the Statement of Common Ground. The Council accepts that there's no 5-year housing land supply.
Correct.
The Council accepts that CS15 and CS16 are the most important policies and are considered to be out of date.
Correct.
And the weight to be attached to those out-of-date policies is a matter of judgment.
It is.
And there's nothing set out, as everyone here knows, but I'll ask the question anyway, there's nothing set out in policy or guidance that tells an inspector what weight to be given to out-of-date policies.
That is correct.
There's no footnote 7 policies that are engaged, so the tilted balance is in play.
It is.
Weight to affordable housing, CD 5.4, para 8.10, sets out that substantial weight should be given to that benefit. Yes?
Yeah, sorry, correct, yes.
And in the context of the 5-year land supply position, the weight that you give to market housing, please.
Significant weight.
And then you set out in your proof, there's a table towards the end of some of the other sort of fringe benefits.
Yeah.
BNG, you give their 10% additional weight. Now, the point no doubt would be put that they're providing more than 10% BNG. So your basis for concluding that only limited weight should be attached.
In the grand and the context of the whole development, this again, it's welcome, but the weight still should be deemed to be a limited weight.
So the overall planning balance, we know that it's the tilted balance, and therefore that the harms need to significantly and demonstrably outweigh the benefits in order for the appeal to be refused. How have you approached that test, and what's your overall conclusion?
So the development is recognised to provide significant housing in an area where we are not meeting our needs according to the 5-year housing supply test, and the weight given to that is obviously been significant. However, the evidence that's been supplied by Mr. Collins and Mr. Wright have been to override that by considerable means, and therefore the balance has been made as such.
And so, in your view, do those harms significantly and demonstrably outweigh the benefits?
They do.
Very good. Thank you, Mr. Baker-Adams. Thank you, sir.
Thank you.
Thank you. Ms. Morrissey, would you like to start?
Yeah.
Yeah, okay.
Yeah. Good morning, Mr. Baker. Can I ask you, if you open the core documents, please, and go to CD 14. So that's the proofs of evidence. And could you open CD 14.11, which says Blaby District Council Planning Proof of Evidence? If you could do that for me. And then if you go to the top, left-hand corner, there should be a tab for the document. Do you see there's a tab?
I do, yeah.
Yeah. And that tab says Proof of Evidence of E. Fawcett. Who is E. Fawcett?
So, I'm lost as to where that is. I can't see that.
So there's a tab. If you open the document,
Yes.
on the top of if you look at I'll show you the there's a tab up here, and the tab for the document, when you open it, says proof of e-Fawcett.
Right.
Do you know who e-Fawcett is, and why it is that your proof says it's the proof of e-Fawcett?
I don't, unfortunately.
Did you use a template?
There could be a template, but
Okay.
yeah.
This is your proof of evidence?
But this is definitely my proof
Right,
of evidence. I
okay,
definitely wrote
thank
this.
you.
Yeah.
Now, your role in this matter,
Yeah.
you were not the author of the officer report.
Correct.
That was done by two other officers, I think, Charlene Hurd and Michelle Hill, who
Yeah.
were the development service team leaders. Is that right?
That's correct. Yeah.
Are they the same level as you?
No, they are team leaders, so they are in effect one down. They are the
Okay.
yeah.
Thank you very much. Obviously, you're giving. This is not an officer. This is not an officer overturn case. It's not where members disagree with officers, but you're the one giving the evidence today.
Yeah.
And when did you become involved? First of all, I think we started seeing your name in emails from mid-March onwards.
Yeah. Yeah. So I've been basically supporting the appeal process as an officer with senior officer experience in planning enforcement and planning appeal matters.
So when was it then, mid-March or earlier, that you became involved? Because we didn't see your name appear, I think, until about mid-March, but maybe you were involved earlier, I don't know.
Yeah, I would say about March. My colleague Charlene Hurd dealt with a lot of this
Yeah.
work, but she left about 3 weeks ago.
Yeah, and you were saying you were providing support as an officer with experience. Have you given evidence at a planning inquiry?
No, this is my first time.
Okay. All right. Can we turn to some contextual matters, which I think are going to be largely agreed? And before we set off on them, I think there are some documents that we're going to keep coming back to. So can I just identify them now so you can have them ready? So obviously one is your proof.
Yeah.
The other is Mr. Cusson's proof and his appendices to his proof, and indeed his rebuttal and his appendices to his rebuttal. I think we will also need to look at Mr. Stacey's proof. And then there are a handful of other documents that I think we probably will go back to multiple times. One is both statements of common ground, so CD 5.3 and CD 5.4. And then I think the final two that we will repeatedly go to are CD 4.1, which is the officer report for our scheme, and CD 13.5, which is the Glen Parver officer report.
Okay.
So if you have those open, there are going to be a handful of others, but they'll be one-offs, so I won't ask you to get them out now.
Would you mind for ease pointing me to the 14 or the CD references for me?
So repeat them, yes, sure. Yes, so CD 5.3 and CD 5.4, that's the two statements of common ground. And then CD 4.1, which is the officer report. And then I think it's CD 13.5, which is the Glen Parver officer report. As I say, there will be some others, but we'll come to those in due course. So my first contextual matter is about the national housing need context. So it's correct, isn't it, that England is in the middle of the most acute housing crisis in living memory?
I would agree with that, yes.
Good, because that's obviously the way in which it's been put by the Secretary of State, and that's in some of the documents that we've got before the inquiry. Secondly, the effect of that housing crisis include higher prices for homes and driving of higher rents.
Correct.
With the result being that too many people are left without access to a safe and secure home.
I agree.
Yeah, and again, that's all things the Secretary of State have said. Now, what's also been said, I think by the Prime Minister, it's recorded in Mr. Cusson's proof, it's recorded in the CDs, that there are 1.3 million households on social housing waiting lists, and a record number of households, including 160,000 children in this country living in temporary accommodation, correct?
I agree, this is a national crisis.
Thank you. And to deal with that crisis, the government has set a target, hasn't it, of building 1.5 million new homes by 2029.
It has, yeah.
And that target is one of the key milestones of the government's plan for change that it published in December 24. Yes?
Correct.
So that's an absolutely key part, isn't it, of the government's policy is to build more homes.
Yeah, totally agree.
And to meet those ambitious house building targets, councils have been told, and again by the Prime Minister as recorded by Mr Cusson, they have to ramp up and deliver growth, correct?
Correct.
Yeah. And the NPPF that we're applying at the moment, the one published in December 2024, requires local authorities to significantly boost the supply of housing.
It does.
Yeah. And the new draft NPPF says the same thing, doesn't it?
It does.
Yeah. And one of the key aims of the NPPF in terms of housing is that local authorities should meet their identified housing need, correct?
Correct.
Yeah. Good. Now, with that in mind, can we turn to the housing situation locally in Blaby itself?
Yeah.
We're agreed, obviously, aren't we, that the council's position as at 31st of March 2025 is it has a 2.78 year housing land supply.
Correct.
So this council is not meeting the requirement set by the government in paragraph 78 of the NPPF to have a 5-year land supply.
No, it is not.
No. And that requirement, as we agreed a moment ago, to have a 5-year land requirement, is one of the most important requirements in the NPPF for housing policy, correct?
I would agree. Yeah.
Yeah, good. Now, you don't grapple in your proof of evidence, your written proof of evidence, do you, directly with the level of need that there is? So you don't, I think, even mention the 2.78 year land supply figure. I mean, I know it's agreed, but you don't deal with the level of need in any detail, do you?
No, I do not.
No. So we know the level of need is 2.78. Well, so we know that the year supply is 2.78 versus what should be a 5-year land supply. The shortfall, as is set out in the documents attached to Mr Cusson's proof in the 5-year period, is 1,255 dwellings, isn't it?
It is.
Right. So the council is short in its 5-year supply of 1,255 homes, correct?
Correct.
Thank you. A 2.78 year land supply, a 1,255 unit shortfall, would you agree that's a severe shortfall?
I think I would.
You would. Thank you. Now, the council also, as we explain in the appendices to Mr Cusson's proof, has been unable to demonstrate a 5-year land supply in any of the last 3 monitoring years back to 2023, correct?
Correct.
So that would show, wouldn't it, a track record of failing to meet the 5-year land supply?
It would over that period of time, yes.
Yeah, it would over that period of time, thank you. Now, the housing need for Blaby based on the standard method, and that is what should be being applied, I understand that's agreed between us, yeah, is 539 dwellings per annum, correct?
Correct.
But if we step away for one moment from the standard method, which we agree applies, there is obviously a lower, out of date now, housing requirement, isn't there, in the adopted plan of 380 dwellings?
Yes, that's correct.
Yeah. And as explained in the appendices to Mr Cusson's proof, even that lower annual figure that's out of date, even if you applied that, you'd still have a housing land supply shortfall in the 5 years of 527 dwellings. Is that agreed?
That would be agreed, yeah.
Okay. Now, as against that, what the actual annual need is, which is 539, it's also correct, isn't it, again recorded in the appendices to Mr Cusson's proof, that there were only 165 dwellings delivered in 2024-25.
I would agree with that, to be correct.
Yeah. So that's a poor delivery rate, isn't it? Is it not?
It is, yeah, it is.
Yeah. If you're delivering only 165 of the 539 per year, that means you delivered, I think it's about 31% against the standard method in that year, correct?
Can I trust your maths on that? Yeah.
Yeah, okay. As to completions, the latest evidence, again, in the appendices to Mr Cusson, 25-26, the latest evidence on completions is that there were 207 completions predicted for 25-26, agreed?
Okay,
Yeah,
agreed.
agreed. Now, I want to ask you about the future position briefly, and can I ask you to take up in the appendices to Mr Cusson's proof, are you using electronic documents?
I am, yes.
Yeah. So if you go, please, So just give me a moment. If you go to CD 14.8.
Yep.
And I'm going to try and find the electronic page for you. Should be easy. Yes, okay. So you go to electronic page 44. Electronic page 44.
Yep, I have that up.
Yeah. So this is our assessment looking at in more detail at the housing land supply position. So this is by Emery Planning, and you'll see at 3.9 there's a heading future position.
Yeah.
And reference is being made in this document to the council's own residential land availability report 24-25. Yes,
yes.
You can see that. You'll see that there's some comments made about housing land supply, which we'll look at in a moment. But then you'll see under the heading housing land supply, it says further updates. The council will look to update its 5-year housing land position in April 2026. But that hasn't happened, has it? Because the council's not published a further 5-year land supply position.
I believe that's correct, yeah.
Yeah. Now, indeed, I think it's explained in this document at 3.10 that last year, so in 2025, the council also said it would publish its housing land supply position in April 25, but in fact it didn't publish it to November 2025. Is that correct?
I believe that's true, yeah.
Yeah. So we're not going to hold our breath for this year's one for now, but we've got last year's, and we're going to proceed on that basis. If you look at 3.9 again in this document and the quotation from the council's position,
yeah,
it says the district council is basing its land supply requirement on the standard method. Talks about 2.78 years. Moving forward, the council has a number of planning applications which is recommended for approval, subject to 106 negotiations being concluded. So, I mean, you may not be able to help me on this, but is that saying that there are other permissions that are not already in the 5-year supply, or that might become in the 5-year land supply, or you may not know what it's meant?
I think it's a combination of both. Since I've started at the council, there's been a number of applications that aren't within that, but have been approved in addition to that.
Yeah, but of course that's because we're using a different base date, so you didn't have to update the completions, and then we haven't done that. But it then says something else which I just want to test with you. It says, you'll see it says that the council, once these sites have permission, the council's certainty regarding delivery timeframes, it will see an improvement in its land supply position. In addition, the council has a number of further planning applications which stand to be determined in the next 12 months. Now, I just want to explore that with you because is it your position to suggest that you agree with this, that the council is likely to improve its housing land supply position? Is that something you agree with?
Yes, I think it is.
Okay. Now, the problem with that, of course, is that if you want to rely on planning permissions that haven't been granted as part of the supply, you need to produce evidence, don't you, in terms of them being deliverable?
I would agree, yeah.
Yeah, and that hasn't been done, has it, in this
Not
case?
from my knowledge,
no.
no.
Okay. And obviously, part of what you're relying on here are applications that haven't even been determined yet.
There was that, yes, I
Yeah.
agree, yeah.
Okay. So we don't even know whether they'll be granted subject to a Section 106. They could be refused, like ours was.
They can be.
Yeah.
I mean, if I can add that obviously as a manager of the department, I have ongoing discussions with our team, and it does seem that a lot more are being approved.
Yeah, but you can't really, can you, for these purposes, place any reliance on them? Because you
I guess I
got,
can't.
No, you can't. Okay, and then if you go in the same document, if you go back a couple of pages, electronic page 39 to paragraph 2.8 of this document, in contrast to that sort of suggested spark of optimism by the council about what's going to happen, the Emery planning document suggests something rather different, because what's said is on that basis the 20% buffer will apply when the 2025 HDT results are published later this year. So there's an assessment undertaken in the paragraphs that precede that by Emery Planning to say that it looks highly likely on the data that's been put forward there that the council will fail the HDT test when that's published later in the year. You haven't led any evidence to dispute that, have you?
No, we've not.
No. And if that happens, the council has to apply an additional 20% buffer, doesn't it?
I believe that to be the case. Yep.
Yeah. And that means that as well as having to provide what you're currently looking at, which is 539 dwellings per year for 5 years, plus a 5% buffer, you have to do it with a 20% buffer.
That would be the
Correct.
case. Yep.
And that would increase the shortfall, we're told, by the Emery Planning document, by a further 404 units.
Yeah.
Correct?
Correct.
Yeah. Now, if you then go to your proof, please, at paragraph 4.4.
Yes, got it.
Sorry, you've got two 4.4s, so it's the 4.4 at the bottom of the page rather than the 4.4 in the middle of the page. So 4.4 underneath the table of
Yep, sorry, yeah.
So you say the analysis above shows that although the provision of homes is given significant weight, the authority has been and will continue to see other locations coming forward that will add to this supply that do not result in important sports facilities being lost, such as what is being proposed here. So the point I think you're making is, again, that there may be these other sites that may come forward, and they will not, or they may not be on golf courses or other recreational courses. I mean, we don't actually know that, do we?
We don't.
No. Okay. And so you say that's been happening, other sites are coming forward, but that hasn't affected the fact that this council has no 5-year land supply.
No, it has not. No.
And it hasn't affected the fact that the analysis we've put forward that you haven't challenged is that you're likely to fail the housing delivery test this year.
Yeah, correct.
Yeah. So even though you've got what you say are other applications coming forward, the reality is you fail on all the housing metrics that the government have set.
We do.
Yeah. And indeed, the analysis from Emery Planning is that the 5-year land supply has decreased each year over the last 3 years.
So it would seem. Yeah.
Disputed? No?
No.
No. Disappointing, I think you said. Sorry.
Yes, I would agree.
Disappointing.
Yeah.
Well, fair enough. Now, I would suggest to you that the way we would characterise the housing land supply position in Blaby, as it now stands, based on the figures that are in the supply, what you've got, what you can show that you've got, the position's dire. Would you agree?
Not dire, no.
How would you characterise it then?
I think, as I've said, it's a significant shortfall.
Significant shortfall.
Yeah, from my reading into many appeal decisions in my career, I've seen more and worse terms for housing and supply of 0 point something or 1 year. The fact that we have a 2, I would suggest that it's not as dire as maybe put.
So significant shortfall,
Yep.
Not the worst.
Yeah.
Yeah. Okay. Not a great accolade, but not the worst. But still, 2.78, nowhere near 5, is it?
Of course not.
Nowhere near 5. All right. Thank you. Now, can we then touch on third point of context, affordable housing? And again, I hope to get through this super quick because we're almost entirely agreed on all of this stuff. But obviously, it is important for the inspector in undertaking the planning balance, isn't it?
Yeah.
To understand the nature of the affordable housing need, correct?
Correct.
Yeah. And the extent of the affordable housing need.
Correct.
Okay, so we're obviously agreed, aren't we, as a starting point, that the affordable housing offered as part of this scheme, 50 units, that can make a meaningful contribution to the shortfall in supply.
It would be a policy compliant meaningful contribution. Yeah.
Yeah, policy compliant,
Yeah.
meaningful
Yeah.
contribution, thank you. And the parties have agreed, haven't they, in the statement of common ground on affordable housing, so that's the one at CD 5.4, which I'll come to in a moment, that the provision of affordable housing attracts substantial positive weight in the planning balance.
Yeah.
Correct?
Correct.
Yeah. So I want to explore with you why it is that is the position, why this matter does carry substantial weight in the planning balance. And the first thing is that, again, the parties have agreed in the Statement of Common Ground on Affordable Housing, haven't they, that the 2022 HENA identifies an affordable housing need of 536 affordable dwellings per annum in the period 2020 to 2041, correct?
Correct.
And the parties agree also, don't they, that applying that level of annual need against affordable housing completions suggests that since 2020 to 21, there's been an accrued shortfall against the need for affordable housing of 2,370 units, correct?
Correct.
Now, Mr. Stacey in his proof looks at that figure in a bit more detail, and he says what that means is that in that period, since 2020, this council has only delivered 12% of its affordable housing need. Do you dispute that figure?
I can't say I can, no.
You can't dispute it, no. Or if you put it another way, 88% of the needs for affordable housing in this district has not been met, correct?
You can put it that way, yeah.
Yeah. That's a poor delivery record for affordable housing, isn't it?
Yep.
Yeah. Now, in the Statement of Common Ground on affordable housing, maybe we should just look at this briefly. There is one point that we don't agree on, and it's recorded in that, and I just want to look at that with you. So CD 5.4, please, the affordable housing, and if you could go, I think it must be right at the end. Yes, matters. Yes, electronic page 12. Matters not in agreement by the parties.
Yeah.
Right. So the one matter I think that's not in agreement is the parties disagree on the appropriateness of seeking to remove the accumulated shortfall in affordable housing in the next 5 years. So there's a dispute there about whether this council should be seeking to eliminate that deficit that you've built up over the last 5 years.
Correct.
Of 2,370 affordable homes in the next 5 years. And that's a matter in dispute, yes?
Yes, it is,
right.
yeah.
Now, by not seeking to address that backlog promptly in the next 5 years, that inevitably means the backlog will grow, doesn't it?
I guess it would, yeah.
Yes. And that means, in the real world, households whose housing needs have not been met will continue not to be met.
Yes.
Yes. And then could you look, please, at Mr. Stacey's proof of evidence, which I think is one of the ones I asked you to get out to have a look at. So Mr. Stacey's proof. And I'd like you to go to his paragraph 8.17. I think, well, it's numbered page 38. It's probably electronic page. Several on, I think. 50, yeah. So electronic 50. It's numbered page 38, and it's paragraph 8.17. Have you found that, Ms. Baker?
Sorry, bear with me.
Yeah, sure.
Yeah, I think I found it, yeah, thank you.
Thank you. So he explains in paragraph 8.17 that if we were to generously assume that all the 1,575 dwellings included in the supply will come forward on sites, and that all of these sites would provide a policy compliant level of affordable housing, 25%, as a proportion of the overall completions, this is likely to deliver only 394 affordable dwellings over the period, equating to just 79 new dwellings per annum. Is that an agreed figure?
I I believe it is, yes.
You're certainly not actively
I can't
disputing
actively
it.
dispute that.
And then he says in 8.19, more realistically, if one were to assume that the past gross affordable housing provision of 22%, i.e. that's what the council's historically been, is to be continued over the next 5 years, the delivery would only be 347 affordable dwellings, so 70 new affordable dwellings per annum. Again, you're not disputing those figures,
I
are
dispute those
you? No. And I mean, whether it's 70 or 79 per annum that you're likely to deliver over the next 5 years, that's only a tiny fraction, isn't it, of the overall affordable housing need.
It is, but yeah, small percentage.
And the 50 units that we are seeking to provide on our site would amount to a good proportion of what you're otherwise likely to deliver in a whole year, correct?
Correct.
50 versus 70 or 79, yes?
Correct, yeah.
Now, in terms of the impact of all of this, obviously we end up talking about figures and percentages and stuff, but if we go to the Affordable Housing Statement of Common Ground, please, at CD 5.4 that we were looking at a moment ago, can I ask you to go to, first of all, paragraph 8.7, electronic page 12. And you'll see at 8.7, it says the parties agree that the affordability indicators in paragraph 7.1 of this statement indicate that housing is becoming less affordable in the district.
Yep.
So one of the real world consequences of all of these numbers is it's getting more and more expensive to buy a house in Blaby, correct?
Correct.
And more expensive to rent a house as well, for that matter.
Yep.
Yeah. So if we go to 7.1 then, which is what's referred to, that starts on electronic page 11. And there are a whole series of affordability indicators set out here, aren't there? Which are all agreed, aren't they?
Yeah.
Yeah, okay. Now, just picking out some of them, because I want to just briefly look at the real-world consequences. We've got, haven't we, an increase on the number of those on the Affordable Housing Register. Yeah?
Yep.
We've got an increase in the waiting times for affordable properties.
Yep.
We've got an increasing number of bids versus available affordable properties.
Yeah.
91 households in temporary accommodation, and that's gone up.
Yeah.
Correct?
Correct, yeah.
And you're sort of going down the list. If you go to the sort of penultimate bullet point, for those seeking a lower quartile price property, so that's those properties that are in that less expensive quartile, the ONS reports the lower quartile for Blaby stood at 8.41 times lower quartile incomes.
Yeah.
So average lower quartile house, 8.41 times greater than the average income. Yeah.
Yeah.
Now, in relation to that, as an indicator of affordability, I think it's explained, isn't it, by Mr. Stacey in his evidence, that lack of affordability ratio is higher than the average in the area more generally.
That's put forward, yes.
Yeah. Because I think the national average is 6.98, so we're higher, and the East Midlands average is 6.77. And that's Mr. Stacey's proof, 7.19. So we're higher than both of those averages, correct?
That sounds right.
Yeah, okay. Now, if you look at Mr. Stacey's proof again, please, if we go back to that. So we were on, you'll need to go back about 3 or 4 pages to paragraph 7.21. So it's numbered page 33. Probably something like page 44 electronically. Something like that. I don't know if you found that.
Yes, fine, yeah.
Office for National Statistics data shows the average private rents in Blaby stood at £9.20 per calendar month, a 53% increase since 2015. Not disputed.
Can't dispute that.
No. And again, that's a real world issue, isn't it? Making rents unaffordable.
It is.
Yeah. So all of that means if you are a young person looking for an affordable home, the situation is, how would you characterise it? Very difficult?
I'd say very difficult,
Very
yes.
difficult. And then if we go back to Mr. Stacey's proof, please, to paragraph 3.2 of his of his proof. So you'll have to. 3.2 is page 6, probably page 80 electronically. But paragraph 3.2 of his proof, and this is the final thing on affordable housing. Mr. Stacey sets out a series of real-world impacts on people when there isn't sufficient affordable housing. Lack of financial security and stability, impacts on physical and mental health, impact on social mobility, impact on children's education, reduced safety in households, being outside support networks, paying unaffordable rents over other human needs such as food, increasing the National Housing Benefit Bill. You'd agree all of those are the real world consequences of a lack of affordable housing, wouldn't you?
I would agree, yes.
Yeah. And then at 3.3, he says the harsh consequences fall upon real households, individuals and children, and that an affordable and secure home is a fundamental human need. You wouldn't dispute that for a moment, would you?
Of course not.
No. Okay, can we turn to policy issues then in the light of that context, please? Section 38(6) of the Planning and Compulsory Purchase Act requires a planning decision maker to consider whether there's been compliance with the development plan as a whole, correct?
Correct.
So the fact that a scheme doesn't, the fact that a scheme is in conflict with one policy, or two policies even, or three in a plan, doesn't mean it's not in compliance with the plan as a whole, correct?
Agreed.
Yeah, because it's been recognised, hasn't it, that in relation to any particular scheme, the policies in the plan can pull in different directions. Some might support it and some might be against it, yes?
Yes, yes.
And so, in order to reach a view about whether there's been compliance with the development plan as a whole, see if you can agree with me. What you need to do is consider all the policies that have been breached, then consider all the policies that have been complied with, and then consider how important are the policies that have been both breached and complied with, and then you reach your overall view.
We do, yeah.
Right. Now, if we go to the main statement of common ground, please, so that's CD 5.3. And I'd like you to go to electronic page 4, first of all, where the reasons for refusal are set out at the bottom of the page. So if we look at the reasons for refusal as set out in this document, starting at the bottom of page 2, under reason for refusal 1, there is an alleged breach of policy CS16 and DM2. Now, I'll come back to DM2, but essentially, as I think you confirmed in chief, the key policy on reason for refusal 1 is CS16.
Correct.
And then on reason for refusal 2, you allege a breach of only one development plan policy, CS15, correct?
Correct.
But we actually agree, and I'll come back to this, but we agree that policy carries very little weight because it's inconsistent with the NPPF.
As per the statement, yeah.
Yeah, that's what it says in the statement of common ground. Yeah, we'll look at that later. Effectively, you're relying on NPPF policy rather than development plan policy under reason for refusal 2.
Under 2, yeah.
Yeah, under 2. And 3 obviously has fallen away, so we don't need to worry about reason 3. So in terms of development plan policies, is it correct that in essence, your allegation of breach of the development plan policy comes down to one policy, CS16?
Yes, I would agree.
Now, we saw DM2 referred to, but in your proof, please, keep open the statement of common ground, but could we just look at your proof for a moment?
Yeah.
Paragraph 2.11. So in paragraph 2.11, towards the bottom of paragraph 2.11, you refer to, 4 lines from the end, conflict with policies CS16 and DM2. Do you see that?
I do see that.
Yeah. And then if you go forward, though, to your conclusion in 5.1, on the last page of your proof, you cite CS16, but you don't cite DM2, correct?
Correct.
So I just wanted to be clear, are you actually relying on policy DM2 as being conflicted with?
Not in this case, no.
Not in this case. Now, we should just pick up here, because I asked you a moment ago about policy CS15, which is under reason for refusal 2.
Yes.
And you said, in essence, you were only really alleging breach of CS16 on green wedge, but you do actually, in your proof, don't you, allege a breach of policy CS15? Do you see in paragraph 5.1?
Bear with me. Don't dispute.
So you say in 5.1 that in relation to the recreational loss, you're relying on the MPPF and CS15.
Okay, yeah, I see that.
Now, I mean, if you are going to place any reliance on CS15, that would have to be in the context that we've agreed that it carries very limited weight because
Correct.
it's in conflict with the MPPF.
Yeah.
Yeah, okay. All right, now, back to the statement of common ground, please. If you go to electronic page 25, just for a moment.
Yeah.
Electronic page 25. Oh, sorry, statement of common ground. The main statement of common ground. Main statement of common ground. Paragraphs 8.14 and 8.15, just to close off this DM2 issue. You say it's agreed in circumstances where development would not be harmful to the functions of the green wedge or areas of separation. DM2 applies. It's agreed the council do not consider DM2 to be the most relevant policy in respect of the appeal. So we can probably forget about DM2, can't we, largely because you've agreed anyway you're not alleging a breach of it, correct?
Correct.
Yeah. I might have to return to it on one point later, but let's leave that for now. Now, if we go back to your paragraph 2.11, I just want to tackle one topic with you now that's slightly out of my order because I'm dealing with policy compliance, but you raise this in the context of policy compliance. So 2.11, and the context here is, I think you start in 2.10 by saying there have been a number of planning applications on green wedges in Blaby, where a very close analysis of the proposals has been required to ensure the aims are upheld and the considerations above fairly assessed. And the considerations above are the green wedge considerations, aren't they? So they're the ones you set out, aren't they, at 2.5 of your proof? Retain the open and undeveloped. They're the ones you went through in chief.
Yeah.
Yes? Yeah. Now, you then say at 2.11, the most recent approved application in a green wedge, CD 15.2, was a very specific in its approach to the impacts on the green wedge. Now, I think that's one of the ones that we've got an erratum reference for, because I think you're referring, aren't you, here, to the Glenparva decision. Is
I
that
believe so.
right?
Let me just double check on the database. Just working.
I think, well, if you look at, I think if you look at your the application that you're...
No, I can confirm that is the one. Yeah,
Yeah, so it is.
Yeah.
So, yeah, because 240439, that is Glenparva, isn't it?
Yes,
You're
it is,
talking about? Yeah. Okay. And you say the proposed development would provide, and this is talking about Glenparva, would provide an opportunity for increased biodiversity through appropriate landscaping and an area of public open space which would connect to existing public rights of way. Okay, so there was public open space which would connect to existing public rights of way, crossing the green wedge. And then you say this, in these respects, a development would enhance the function of the green wedge in this area and accord with criteria B and C listed in the final section of policy CS16. Now, you then seek to contrast that with our case in that paragraph, correct?
Correct.
Now, I just want to understand that with with you, please. What you're saying is that the conclusion that was reached at Glenparva was that because there was increased biodiversity provided, through appropriate landscaping, and because there was an area of public open space which would connect to existing public rights of way, the view that was taken by officers was there's compliance with criteria B and C, correct?
Correct.
So if you look at back on your proof at 2.5, those two factors, in your view, biodiversity enhancement through appropriate landscaping and the provision of public open space which would connect to existing public rights of way, were enough to satisfy compliance with B and C, i.e. retain and create green networks and retain and enhance public access.
In this very specific case, yes.
Yeah, well, in that case, that's right.
Yeah.
Okay. So I want to explore that with you further, because obviously I put to you the point straight at the beginning, and then I'll come to some of the detail of it. But we are providing biodiversity enhancement, a net gain of at least 10% through appropriate landscaping, correct?
Yes, that's correct.
And we are providing a large area of open space, circa 64%, that also connects to existing public rights of way, correct?
Yes.
Yeah. And if we then consider that in a little bit more detail, could you go, please, to the officer report for Glenparva, which is CD 13.5. And if you just look at the very top of the document on page 1, we'll see that that was an outline application for the erection of 31 dwellings and associated infrastructure, including public open space, correct?
Correct, yeah.
Yeah. And then if you go down to electronic page 8, please, of this report.
Yep.
And electronic page 8, you'll see that it's said, right at the bottom of the page, that site was a site of 1.9 hectares in total of grazing land, correct?
Yes.
In the Green Wedge?
Yes.
Yeah, okay. If you go over to the next page, electronic page 9, you'll see there's a heading, the proposal.
Yes.
And at the last paragraph, it says approximately 1.1 hectare of that 1.9 hectare site was proposed to be public open space, including play space, footpath, connections, etc.
Yeah.
Yes. Okay. Thank you. Now, in our case, we're providing, because we're a bigger site, 10.5 hectares of public open space, green infrastructure, etc. And that's agreed, I think, isn't it, specifically in the Statement of Common Ground at paragraph 5.1, third bullet, correct?
Yeah, yes.
Yeah. So our total site area is 16.06 hectares, and we are providing 10.5 hectares of that as public open space. So in absolute number terms, we're providing about 10 times more public open space, just in absolute terms, yes?
Yeah.
Yeah. And that's a percentage of the site. Glenparva, 1.1 out of 1.9, that's about 58% of the site public open space, yes?
Okay, yeah.
That's against our site, which is somewhere between, depends which document you look at, 64 or 65%, correct?
Yeah.
Right. So we're actually delivering more public open space green infrastructure in absolute terms and in percentage terms than Glenparva.
There's benefits, yeah.
And in the Glenparva case, the officers concluded that that meant there was compliance with criteria B and C, yes?
In this case, yeah.
In that case, yes. And in this case, you say not.
So in this case, we're saying that the open space provided, I think that's more of the arguments that against the development on the golf course. So.
Hang on, I don't understand that answer. What do you mean by that? I mean, I'm just trying to establish with you a very straightforward point. These were both sites that are in the Green Wedge, correct?
Correct, yeah.
Right. They're both sites that were open and undeveloped.
Yeah.
Yeah?
Yes.
Yeah, although, I mean, actually, our site is more developed because it's got golf buildings and everything else, which we'll come to, a car park, etc. But let's say they're both undeveloped, so let's agree that they're both undeveloped. Both sites are providing public open space, yes?
Yes, they are, yeah.
We're providing more public open space and green infrastructure, both in absolute terms and percentage terms, yes?
Yes.
Yeah. And we're also providing an increase in biodiversity, which was relied on in relation to the Glen Parva case, yes?
Yes, sorry, yes.
Yeah, and then if we look at Mr. Can we go to Mr. Holliday's proof that you looked at in your evidence in chief, to his figure 18? Because part of your evidence in chief, so figure 18, please, which is on page... I think it's on page 31. Yes, page 31 is figure 18.
Yep.
You had a discussion with my learned friend about what we were providing and the connection issues with other public rights of way. But if you remember, in Glen Parva, your summary of the decision was that one of the things relied on by the officers there to say there was compliance with both B and C of the criteria was that they were providing public open space that would connect to existing rights of way. Yes?
Yes.
We are providing public open space in the Green Wedge that will connect to existing rights of way. Correct?
Correct.
Right. Can I suggest to you that if the matters that you say were relied on by the officers to show compliance with criteria B and C of CS16, if those matters were sufficient to show compliance at Glen Parva, they must also be sufficient to show compliance in our case. Do you agree?
In part, but I would base it on the specifics of the actual application itself and the other benefits and pros and cons of developing.
No, I don't think that's right at all. B and C, I mean, if you look at your proof, you set out, don't you, at 2.5 of your proof, the criteria that we are concerned with here: retain and create green networks, and retain and enhance public access to the Green Wedge. And what got the officers to the conclusion that those were complied with at Glen Parva was two things: the provision of an enhancement of biodiversity through landscaping, correct?
Correct, I can see that. Yeah.
And it also got to it through the fact that they were providing public open space that connected to existing footpaths, correct?
Correct.
Both those factors are present in our case, correct?
I think we had a discussion about B and whether the development would go towards those connections between the countryside and the open urban spaces and the urban areas.
Yes,
I think
but
that's where there's a disconnect. That's where there's a disconnect.
well, there's not a disconnect, is there? Because what was said at Glen Parva was that public open space would be provided that connected to existing footpaths.
But those existing those footpaths were in the countryside, where in this case they're not.
But they these footpaths lead straight into the countryside, don't they? I mean, go back to figure 18 on page 31. I can essentially, I mean, you accept that there are ways to walk from the public open space to the country park, yes?
Country park, yes.
Yeah. You could walk from the site, could you? on that basis to the other footpaths one sees there to the west. Yes?
Yep, sorry, yeah.
And indeed to the east.
Yeah.
It's possible to walk from the public open space to those existing rights of way, some of which are in the countryside. Yes?
If those footpaths are in the countryside, then
Yeah.
yes, I would agree.
Okay. And then if you do agree that, then there's really no difference, is there, between us and Glenparva? Correct? Well, there isn't, is there?
No?
No. Good. Thank you. Now, before we leave Glenparva, can I ask you, please, to go to electronic page 41 of the report? So that's the very last page, I believe, of the officer report, electronic 41.
Yeah.
And we'll come to the overall conclusion of the officers. Now, one difference between Glenparva and us, which we haven't touched on, of course, or at least not directly, is that was a scheme for 31 dwellings, and we're providing 200 dwellings, correct?
Correct.
Yeah. Now, it says in this last page, in conclusion, do you see that? It's on the middle paragraph. Whilst the site's located in the Green Wedge, where such development, which has not been allocated in the local plan, would not normally be permitted, it's acknowledged that in the context of the Council's lack of 5-year land supply and the tilted balance, the provision of housing carries significant weight in the planning balance. The same would apply here, correct?
Yes.
Yeah. Other benefits include the provision of much needed affordable housing in a location where there is significant need. That's also true here, correct?
Correct.
Economic benefits during the construction phase and to the local economy through household spending, also present here.
Correct.
Yeah. And improvements to local infrastructure and provision of on-site open space and enhancements to biodiversity. Well, that's the point we've just discussed, correct?
We've discussed it, yeah.
Yeah. Overall, the proposal would conflict with some policies in the development plan, but in the context of a tilted balance, any harm is required to be significant and demonstrably outweighed. And in this context, accounting for the significant contribution which development makes to housing land supply, it is not considered that the harms identified significantly and demonstrably outweigh the benefits. Okay. Now, just on that, the officers do say there, don't they, that there is some conflict with the development plan. Now, we know, don't they found there to be compliance with criteria B and C, because we've just been through that, yes?
Yeah.
So presumably the conflict was, wasn't it, with A, the open and undeveloped provision in CS16, yes?
Yes.
Yeah. So the same thing that we would conflict with here, correct?
Correct.
Right, okay. So I'm going to leave Glenparva for now. I want to talk about a little bit more about other policies for a moment, because you remember that where we started on this was that you're effectively principally relying on one policy as being breached, CS16, possibly with CS15, but that carries very limited weight. And I said, and you agreed, that one had to consider all the policies that were relevant and conclude overall whether there is compliance or not.
Correct, yeah.
Now, if you look at your proof as a whole, you do not mention, let alone analyse, compliance with any policies other than CS 15, 16, and to a very limited extent DM2. Is that correct?
Reading it, yes, I would agree, that's correct.
So, is there anywhere in your proof where you undertake the assessment that's required by section 38.6 of looking at which policies are breached and which are complied with and deciding whether there's compliance with the plan as a whole?
So I understand my learned friend's point. One of the things that one does in preparation for an inquiry is agree a statement of common ground. And in this case, an extremely lengthy and detailed statement of common ground that then allows a proof of evidence to focus on the key issues in dispute. There are reasons for refusal with policies cited in those reasons for refusal which have been addressed and analysed by Mr. Baker-Adams. I'm unsure where this goes and therefore what the purpose of a long statement of common ground is if we're now going to have to go over things that we've agreed. we've agreed compliance to those other policies in the development plan. That's why they're not the reasons for refusal.
Yes, but one has to reach a view about compliance as a whole. So
yeah, shall we see where it,
that's the question. I think if we were going to go through all of those policies, I don't see where it...
well, shall we see where it
Mr. Baker,
goes? If it's succinct,
I
then I'm happy to.
Well, I will
go
push.
with it.
I am going to push on with it because Mr. Baker Adams has agreed something which is absolutely 100% correct, which is you have to look at the policies breached and those complied with, and then how important those policies are that are breached and complied with. And the point I've made to Mr. Baker Adams, which is accepted, is he's got no analysis of the importance of the policies that are complied with at all in his proof. So I need to explore that with you. Okay. There is nowhere, is there, where you express any view about the importance of any of the policies that are complied with?
Not implicitly, however, I
Yeah.
would say that I feel that I have demonstrated that there is weight to each of these policies, and I appreciate, though, that a more rounded view should have been given.
Well, you say you've demonstrated there should be weight to each of these policies, but, I mean, not in anything you've written in your proof.
Well, like I said, I think the table provides some sort of reassurance to the inspector that all these considerations have been made and been given weight accordingly.
Well, we'll talk about the table later on, but the table clearly isn't directly addressing the policy compliance, and it doesn't actually include all the things that you agree in the Statement of Common Ground are policies that are complied with. So let's look at it in a bit more detail, please. Now, if we go to the Statement of Common Ground, CD 5.3, electronic page 12 and 13, so the Statement of Common Ground says the parties agree the following policies are relevant to this appeal, and the most important policies for determining this appeal are denoted by an asterisk. So just to be clear, and I think this was implicit in what Mr. Robson just said when he intervened, but although it doesn't say so in terms, the council agrees that if there's a policy listed in these tables that's not in the reasons for refusal, it's agreed to be complied with. Correct?
I would agree.
Yeah, good. Now, in terms of the policies that are most important, so we've agreed a number of policies, haven't we, that are most important for the determination of the scheme. So those are the most important policies on both our views, yes?
Yeah.
So you obviously deal, if we look down that table, you obviously deal with CS16, which is one of those policies, which is green wedge, yes?
Yeah.
And you obviously also deal, at least to some extent, with, I think, CS15 updated, which is the open space one. So that's two of the policies that are asterisked as being most important. There are two others that are asterisked as being policies most important, aren't there? There's CS5, housing distribution, and CS1, strategy for location of new development. Yes?
Yeah.
Right. Now, if you go down to table 2, there's also policy DM2 is said to be agreed to be one of the policies most important for determination of the appeal. But I mean, you've made clear you're not saying that's breached, yes?
Yeah, correct.
Right. Thank you. If we look at CS1 and CS5, which you don't obviously address directly in your proof at all, and which we agree are policies most important for the determination of the appeal, can I ask you to see if we can short-circuit these policies by going to Mr. Cusson's proof, to his main proof, paragraph 4.5? I can't be right. 4.35, sorry. 4.35. So he says about CS1 and CS5, it's considered that some weight can be afforded to policy CS1, in this case in relation to the aim to direct development to the most sustainable locations in the district, of which Blaby Town has identified as a tier 2 highly sustainable location for development within the district settlement hierarchy. Policy CS5 further reinforces the position of Blaby Town as a key settlement in the district with a wide range of services. The development subject to this appeal would therefore be located within a highly sustainable location within the district, and consequently would accord with the aims of policy CS1 and CS5. Is all of that agreed?
Agreed, yes.
It is. So those are two policies that are amongst the most important for the scheme, and they are agreed to be fully complied with. Yeah.
Yeah. Yes.
So if you were carrying out the overall development plan compliance balancing exercise, you'd have to weigh any breach, wouldn't you, of CS16 against the fact that there is full compliance with those two most important policies.
Correct.
Yeah. And that's not an exercise you do in your proof, is it?
No, it's not.
No. Okay. Thank you. Now, obviously, because you haven't got a 5-year land supply, the policies most important for determining this appeal are all deemed to be out of date, correct?
Correct.
But you agree, don't you, that CS1 and CS5 remain policies to which weight can be given?
Yes.
Yes. Thank you. Now, just taking it very briefly, and maybe we can do it from the table, or the tables in the Statement of Common Ground. Amongst the other policies, they're not ones that we've specifically agreed are policies that are most important, but there are a number of other policies which we agree are complied with. And can I just highlight a few of them to you? So first of all, affordable housing, CS7. We agree that your policy on that is fully complied with here.
Yes.
Yeah? Although it may not be one of the policies we've agreed is most important, it is an important policy, your affordable housing policy.
It is.
Yeah. And it sets out, doesn't it, a number of key objectives, including to provide sufficient housing for people, yes?
Yes.
Okay. Similarly, same for CS8 on mixed housing?
Yes.
Yeah. CS14 requires provision of green infrastructure. Yeah.
Yes. Yeah.
And that's fully agreed to be complied with.
I believe so.
Yeah. Well, I think Mr. Collins told us it was complied with in arboricultural terms. Yeah.
Okay. Yeah.
But, I mean, you don't allege it to be breached, and it's in this list, so you must agree it's complied with full stop, mustn't you?
Should agree myself, but yes, I would
Yes.
agree. Yeah.
Yeah. And then obviously you've got CS24, the presumption in favour of sustainable development. That's applicable here.
Yeah.
That's complied with, yes?
Yes.
BNP8 in the neighbourhood plan, if you just go down to that, that's design of new development, and design is an agreed matter between us, isn't it?
It is. If I can add one addendum,
Okay, go on.
that I do feel some of this does play into design arguments, such as the green wedge and the coalescence of settlements. I think there is a design argument to be made. I appreciate, on retrospect, it probably could have been made clearer in my proof, but I do believe that there's something in that that maybe needs to be discussed or looked at.
Well, hold on a moment. You have not alleged policy BNP8 to be breached.
No.
No. It's not in the reasons for refusal.
It is not,
It's not dealt with in your proof.
of course.
No. And it's in a table that you agreed with me a short few moments ago.
Yeah.
You agreed all these policies were complied with.
Correct.
So we are fully compliant with your design policies.
I would agree. Yeah.
You would agree?
I would. I just thought I'd mention that.
Yeah, I will come back. I mean, given your answer, I will come back to that when I talk about maybe the green wedge later and just touch on design. But I think we can move on because you've agreed with all of that. Now, can I then ask you again, please? Policy DM2. I just want to touch on this briefly because you're not relying on it. But again, that policy also talks about the need for good design, doesn't it?
Does? Yeah.
It does. And you're not alleging that that's breached, again?
Yeah, as per the, yeah.
Yeah, so same point.
Yeah,
Okay. Same point, all right. Thank you. Now, could we then turn to the policies that we are in dispute on, which is CS16 on the green wedge principally, but I will also touch on CS15 and the MPPF. Your proof, first of all, please. Your proof. paragraph 2.4. CS16 states, the need to retain green wedges will be balanced against the need to provide new development, including housing in the most sustainable locations. The Council is content that this is the approach that they are taking with the decisions it has made affecting green wedges. So the way I put it in opening, and I think this was touched on in your evidence in chief, is that there's an internal balance within policy CS16. Would you agree with that?
I would agree, yes.
Right. So just to understand it in terms of what that means is that you could find, couldn't you, that the green wedge objectives were offended by a scheme, right? That there was harm to green wedge purposes, but it was still compliant with policy CS16 because of housing need.
Yes, I would read this,
Yes.
yeah.
And I mean, the reason you make the statement that you do there is because the policy itself says in terms, doesn't it, that green wedges will be balanced against the need to provide new development, including housing in sustainable locations. You're essentially setting out word for word what the policy says.
Yes.
Yeah. And indeed, one of the other principles that we've debated already, I think I debated with Mr. Collins on the first day, is there's an objective in that policy CS16, isn't there, about development form, guiding development form.
Yes.
Yeah. And if you're talking about guiding development form, that's not a prohibition on development, is it? It's a guide on how development forms.
Yes, I would interpret that policy to, control.
Yeah.
We don't control, do we? But how we manage how a development would look. So where the green wedge lies, and that's how you develop accordingly.
Yeah, but I mean, it contemplates the possibility, doesn't it, inherently, of there being some development in green wedge.
I would also read it that any development close to or outside of the green wedge will also be kind of inferred by that policy reference as well.
All right, well, let's look at the policy then, shall we? So could we go to CD 6.11? And if you go to electronic page 3, underneath A to F, you see the text that you've sort of cited word for word in your brief, yes? Yeah. Okay, good. And then what I was going to ask you to just look at briefly is you see on electronic page 3 again, at the top of the page, or towards the top of the page, green wedges are important strategic areas. They will be designated too. And then one of those reasons for designation is guiding development form. Yes.
Yes. Yeah.
Right. And then if you look at the objectives, I looked at these briefly with Mr. Collins. To maximise sport and recreation is the first one of the strategic objectives that this policy fulfils. Yes.
Yes.
So I'm going to come back to that when we talk about the recreational provision. The second one is about protecting species, habitats, landscape and geology. Well, on ecology, there's no ecology reason for refusal, correct?
Yeah.
We agree there's a 10% minimum PNG, correct?
Correct.
Right. There's no geology issue, is there?
Not where off, no.
No. And on landscape, it's agreed there's no unacceptable effects.
No landscaping.
No. Okay. If you then look at the next objective, the next one's about cultural heritage. That's not breached, is it? Here?
No.
No. And then minimise flooding. That's not breached, correct?
Correct.
And then there's one that says, deliver the transport needs of the district and encourage and develop the use of more sustainable forms of transport. Well, we agree, don't we, that one of the benefits of this scheme is that it's located in a sustainable location?
It is, yes.
Yeah, okay. Now, can I then go to your paragraph 2.6 of your proof? So 2.6, you say, without expanding too much of the proof of evidence to be provided by Mr. Collins, I adopt, the development would reduce the open distances between Blaby, Whetstone and Countersthorpe, further merging the settlements. This would be contrary to CS 16A,
as set out above. So you're finding a conflict with or harm to policy CS16A, correct?
Correct.
Yeah. And then if you go to your last paragraph in your conclusion at 5.1, you say the site's located within the Whetstone Blaby Countersthorpe Green Wedge and the development will cause harm to the Green Wedge. And I think that should be not allow it to perform its important functions contrary to policy CS16 of the Blaby local plan. So that's a finding that because it's having an impact on some of those functions, you find there to be breach of CS16, yes?
Yes.
Yeah. So where is it in your proof that you carry out the internal balancing exercise within policy CS16 of not simply treating harm to Green Wedge as breach of CS16? Where do you balance the housing need inside of the policy?
I'm just trying to grapple with the question, sorry. Could you put
Yeah.
it again or put it?
So you agreed with me that there's an internal balancing exercise in
Yeah.
policy CS16,
Yeah.
which means that you can find harm to Green Wedge objectives and purposes, but still find the policy is complied with because of housing need.
Yeah.
And what I was asking was, all I've taken you to so far are those two paragraphs where you say, well, there's some harm to the functions of the Green Wedge, therefore the policy is breached.
Yeah.
So where do you weigh up whether the policy inside the policy might actually be complied with because of the need for homes?
I would refer myself, the inspector again, to that table where the impact on the Green Wedge has been given weight and how that's balanced against the housing issues that we've highlighted in the start.
So if you go to your table, that's on the penultimate page. I mean, this is you undertaking the overall planning balance exercise, is it not?
In summary, yes, in summary.
Yeah. But you've already concluded by this point that you think there's a breach of CS16, correct?
Correct.
So is it in fact the case that although you've done the overall planning balance, you didn't actually carry out that balance within policy CS16?
Owing to the evidence that I have been provided by Mr. Collins,
Yeah.
that extensive evidence that there is an impact to that Green Wedge, and analysis has been undertaken.
Right. But that's just one part of the analysis. That's whether there's an impact on the policy objectives. It's not answering my question about where you did the internal balance of whether the policy might still be complied with, notwithstanding those harms. I mean, I think the answer is very straightforward. You haven't done that explicitly in your proof.
I would read an implicit
No.
mention. No, it could be better.
All right. Well, that's fine. Now, I just want to explore a few elements of this further. So, could we just perhaps look at your paragraph 2.15 of your proof? So this is another place where you set out harm to the objectives of policy CS16, and you say the application has been assessed as providing what's viewed as an unacceptable encroachment. You talk about merger, and you say whilst open space is provided, it would not provide the same access to green space that exists in order to be a green lung into urban areas as it presently exists. And then you say the landscape would change as a result of the development, failing in part to guide development form, and as a result would be contrary to the objectives of policy CS16. So again, I mean, that's all about, isn't it, whether you think there's any harm to the objectives, correct?
Correct.
Yeah. And I've already talked with you about the green lung aspects by reference to this case in Glen Parva, so I'm not going to go over those. But when you say here, whilst open space is provided, it would not provide the same access to green space that exists as presently exists, is the way you then put it. I mean, the comparison you're making, though, is between a site which will open up 10.5 hectares of public open space, correct?
Correct. However, I believe Mr. Collins has made submissions to the fact that this use will be primarily to those who would occupy the houses within this scheme.
Well, yeah, let's explore that. He does refer to it being used by the local population, but local population doesn't necessarily mean, does it, just the people in the scheme?
No, but I think that's the point I was trying to make with this bit, in the fact that currently the site is well used by people from outside. We don't believe that the proposals would necessarily improve that situation.
Well, I mean, let's break it down, because I think you're merging quite a lot of different things here. So let's break it down. At present, this site provides very limited public open space. It provides a footpath through the site, correct?
Correct.
The rest of it is a golf course that is privately operated and you have to pay to play, yes?
Correct.
So that's not public open space.
Correct.
In the scheme as built out, 10.5 hectares of the site will be open space, green infrastructure, play, correct?
This is one of these points that I find interesting, because we say will be, but the plans are indicative. And I think I've made that point in submissions. Whilst there's a Section 106 agreement, the plans proposed are those that could be changed and do not reflect potentially what will actually go out on the site as developed.
Right, well, I'll come to that, but I can probably short-circuit that answer by asking you to go, please, to the Statement of Common Ground, CD 5.3. Paragraph 5.3 as well. The application proposed the erection of up to 200 dwellings, including 25% affordable units, and then third bullet, approximately 10.5 hectares, of which the majority would form publicly accessible, formal and informal open space, including an 11 by 11 youth football pitch, community orchard, and natural green spaces with walkable routes. So we've agreed, haven't we, that that is what is proposed by this scheme, correct?
As per the description, yes.
Yes. And if you then go to paragraph 8.24, scheme benefits, it is agreed that the following scheme benefits are identified. And the third bullet, significant new areas of accessible formal and informal public open space through landscape planting and habitat creation, and including an 11 by 11 football grass pitch. So we've already agreed in the Statement of Common Ground, and you're not going to row back from it, are you, that this scheme will be providing a significant area, 10.5 hectares of new public open space.
The indicative plans provided should show that that will be provided.
We will be providing that as part of this scheme.
Okay.
Any other question on this is about conditions, isn't it?
It is,
Right.
but I suppose, yeah, maybe that's a point for that section.
Well, I mean, there's a condition in the agreed conditions about the provision of the public open space, correct?
From memory, I think there is, yes.
Yes. And we've agreed those conditions, correct?
Yes, I think we have.
Right. And this is we'd have to make a reserve matters application, wouldn't we, ultimately? Correct?
You would, yes.
Yeah. And the council are the determining authority for a reserve matters application.
We would, yeah.
Yeah. And you could have regard to the conditions that were imposed, yes?
Yeah.
In the light of that, can we just come back to this? It is actually agreed between us that this scheme will provide significant new areas of accessible formal and informal public open space, correct? That's what you've agreed in the Statement of Common Ground.
As per the Statement of Common Ground, yeah.
Yeah, and you can't go back on that, can you?
I can't.
No. Good. Now, just in relation, just in relation to that, I was asking you something much more straightforward, really, which was what that means is the amount of public open space on the appeal site will be far greater with the scheme than without the scheme, correct?
Correct.
Right, good. Now, back to your 2.15, where we started, you say about 5 lines down, the landscape would change as a result of the development, failing in part to guide development form. So I just wanted to explore that with you. That suggests the approach that you're taking is that if the landscape changes, then there is going to be some conflict with this policy in terms of guiding development form. Is that what you're saying? Any landscape change?
I would agree. It would change the look of that area. Yes.
So your approach, just so I'm absolutely clear, is any change to the landscape would impact on the objectives of this policy.
Yes.
But of course, we agree, don't we, that there are no unacceptable landscape impacts in the medium term, don't we?
We do, but it does not mean I have to negate to look at that policy and how it responded to with this application.
You don't have to negate it, but it can't be right, can it, to say that any change to the landscape would offend the principles in this policy?
No, but I would disagree. There's a factor of determination that we need to consider how that's happened.
And can I just raise this here with you, and I think we probably need to take a break then, but I just want to raise this with you. This is a proposal for 200 dwellings, correct?
Correct.
It's also proposing the resiting of the existing retail, leisure and sui generis uses. I think that's 600 square metres, I think is the condition.
Yeah.
And there's also, of course, as one would expect, the supporting highway and drainage infrastructure, correct?
Correct.
Despite that, as we've seen that we've agreed, we're providing 10.5 hectares of new public open space, correct?
Correct.
And notwithstanding the fact that this site lies at the edge of a settlement, within a green reg, and is largely currently undeveloped, we agree, don't we, that there would be no unacceptable landscape and visual effects within 15 years, correct?
Correct.
Bearing all that in mind, you'd accept, I assume, that's a pretty big tick in the box for this scheme. 200 homes, all that development, and no unacceptable landscape and visual effects, despite being at the edge of settlement. A tick in the box, a positive?
Yeah, I'd say it is, yes.
Yeah. All right, that might be a convenient moment to take a break, because I think we've been going for quite a while.
Okay, so we'll round up perhaps to 10 to 12 and recommence. So inquiries adjourned. Thank you.
Yes, so just before we start, I've spoken to Mr. Robson about this. I just want to record something. I'm not going to make anything more of it, but in the break I overheard the witness discussing evidence with a couple of his colleagues, and I think it's obviously his first time giving evidence. He's been told by Mr. Robson he can't do that. I'm not going to make any more of it, but obviously it shouldn't have happened, and I want it recorded that it did happen, but I'm not going to say anything more about it.
And equally, I apologise for that.
Thank you. Can I just come back to one thing that we briefly discussed earlier? When we were discussing our scheme versus Glenparva, if you remember, you raised then, and I think possibly even later on, uncertainties about the delivery of green space and public open space because we're an outline scheme. Yeah, I mean, Glenparva was an outline planning permission, wasn't it?
It was, yeah.
And it had a landscaping condition.
It did.
Yeah. So in that way, it's no different in terms of the certainty of delivery to us, correct?
Yes, true.
Good. Okay, now we're still talking about green wedge policy, and there are a handful of other things I need to ask you about CS16 and green wedge policy. Obviously, CS16 is one of the policies we've agreed that's most important for the determination of the appeal, yes?
Yeah.
Given there's no 5-year land supply, it's deemed to be out of date, correct?
Correct.
Right. Green wedge is one of those policies which is inevitably a constraint, isn't it, on housing delivery, correct?
Correct.
Yeah. So the absence of a 5-year land supply and the fact that this policy is deemed to be out of date, that must mean, must it, that we give it some level of reduced weight as a policy?
Some level, yeah.
Some level. What level of reduced weight are you suggesting?
I would suggest it's a degree of which there's a conflict. So obviously, if a lot of the things are passable, then that conflict would be reduced.
No, but that's about compliance with the policy. In terms of its weight as a policy, because it's a constraint on development, there's no 5-year land supply. We reduce its weight,
okay,
don't we?
Of course, yes.
Yeah. Okay. Well, are you going to offer any? How much weight do we give it? Do we give it limited weight, moderate weight? What are we giving the?
I think in my proof I've given it.
No, but that in your proof you're not discussing the weight of the policy. You're discussing the weight to the overall issue. I mean, you may not have thought about it, but maybe we can just leave it in. You agree that some reduction in weight is possible. It must be applied. Okay, fine. Now, okay, I'll leave that. Now, a few other matters on the green wedge policy stuff. Your proof, please, paragraph 2.8. You say in the appellant submission there is no reference to the golf course being compliant with the purposes and criteria of green wedge policy. It is, however, also not explicitly stated in the statement of common ground. They are contesting that the majority of the land does meet the policy criteria. So just explore that with you. You're saying that a golf course is a green wedge compliant use, correct?
Yes.
Yeah. There are a number of other uses now on the site, aren't there? There was a beauty salon, gym, restaurant, dance school, hair salon. They're not green wedge compliant uses, are they?
They're not.
No. Okay. And in CS16 itself, and we can go and look at. Do you want to look at that again? We were looking at it in the core document, CD 6.11.
Yeah.
That policy refers, doesn't it, to, if you go to the top of electronic page 4, it says, so it starts over the page, Council will encourage active management of land that promotes environmental improvements, recreational facilities other than built development, yes?
Yes.
Right. And then, if you look at the next paragraph, it says uses that are appropriately located in green wedges include agriculture, allotments, not garden centres. I discussed that with Mr. Collins. Outdoor recreation where associated buildings are small in scale.
Yeah.
Now, your evidence that we looked at a moment ago in that paragraph was that the majority of the land meets the Green Wedge criteria. I mean, the buildings on the site, the car park, the hard standing, etc., they're not, are they, small in scale?
They're not in terms of their built form.
No.
Yeah.
So when you say, I think what you mean then is when you say the majority of the land meets the policy criteria, you mean the actual golf course itself rather than the built
the
form?
green, yeah.
Yeah, okay, thank you. Right, then in your proof release 2.9, we may have dealt with this earlier, but you say, on providing a green lung into areas, it's considered the level of public access to the green wedge proposed by developments not comparative to the existing offer of the golf site. And then you say, it's adjudged this would be more of a benefit to those of the houses proposed and not public access to the green wedge as required by C. And then you refer to Mr. Collinge's evidence. I mean, I think we've been through all of that, haven't we? Yes?
Yes, I believe we have, yeah.
Yeah, okay. Good. Now, if we look, please, back to one further point on this. In your proof on page 4, paragraph 2.5, when you set out the specific considerations of green wedge policy, just on C rather, retain and enhance public access to the green wedge. Well, we know the only public access at the moment is the footpath, correct?
Yeah,
That is being retained, correct?
it is,
Yeah.
yeah.
And in terms of enhancing public access, we've agreed there will be more public access post permission than without permission, correct?
Yes.
Okay, thank you. Now, finally on CS16, I think, could you just look at briefly at Mr. Cussen's main proof again, 4.53. And he says, second line down, I note that in the context of policy CS17, which identifies areas of separation, the green wedge designation is not even the top of the council's hierarchy of land identified by the local plan as performing the function of preventing coalescence. So policy CS17 isn't applicable in this case, is it?
No.
No. That sets out what are called areas of separation, correct?
Correct.
And it applies to certain settlements, but not including the ones we're dealing with, yes?
Yes.
And the basic point Mr. Cussen's making is that that policy provides a stricter control over coalescence than does the green wedge policy. Do you agree with that?
It's a more direct approach, yes.
Well, more direct, but is it stricter?
You just bear with me, please.
I wonder if I can help you by putting it a different way, seeing if you'll agree this. I think what Mr. Cussen explicitly says is that there's a hierarchy of protection of settlements from coalescence, and CS17 sits above CS16 in that hierarchy. Would you agree with that?
If I'm being honest, I'm not entirely sure how that assessment has been made.
Right, but it doesn't matter
whether you understand how the assessment's been made. I'm asking whether you agree that CS17 sits above CS16. Is the answer yes or no?
No.
You don't agree?
No.
So what are they, the same level of protection?
I think there are different policies for different areas.
But they're both dealing with coalescence. They must be doing something different, otherwise there wouldn't be any point, would there?
But my assessment would be that CS17 is very specific to these areas. So there's something about these areas which means a detailed assessment of how these villages interrelate. So when you have an application between Narborough and Huncook, for example, you need to ensure that the...
Okay. Well, given that then, can we go back to my original question?
Yeah.
Is CS17 stricter than CS16?
The only reason I'm questioning it are the references to similar things that CS16 and CS17 overlap. So you've got the need to retain areas of separation to be balanced against, again, this mention of housing.
Well,
I guess there's less criterion to be met with this policy. So if you were to take it on that basis, then yes, this policy does read to be a bit more stricter in terms of development.
fine. A bit more stricter.
Yeah.
Okay. A bit more stricter. All right. Thank you. Now, I'll leave CS16. Can I just briefly discuss neighbourhood plan policies with you, because the officer report cited, didn't it, breach of a couple of neighbourhood plan policies, BMP2 on green wedges and BMP5 on settlement boundaries. But as we've agreed in the statement of case, those things weren't included in the reasons for refusal,
No.
and you're not advancing those.
No.
Okay. Thank you. Thank you. Right. I think just finally then, we've dealt with Green Wedge policy itself. I want to just pick up these further matters. So first of all, you remember in your reason for refusal 2, which is actually the recreation one, you rely on both the local plan policy and the MPPF policy, correct?
Correct.
Yeah. In relation to reason for refusal 1 on Green Wedge, there is no reliance, is there, on any MPPF policy?
I don't recall, but let me just double check. No, there isn't. No.
No. Okay, thank you. Now, obviously, we've discussed already how Green Wedge policy requires a balance to be struck between meeting housing needs and the objectives. I want to look with you, please, if we could, at one of the appendices to Mr. Cusson's main proof. And this is his appendix 10 to his main proof. If you're looking at it electronically, I'll have to find you the page reference, which I'll do in a second. Yes, if you go to that page 78, you should have a plan.
Yes.
A plan on there. So I just want to run through this with you, and you touched on this in your evidence in chief about other sites where there have been grants of permission in the Green Wedge. So just looking at it, obviously we can see, can't we, if you look at the appeal site to start with, to the north-west of the appeal site, that's the Davidson scheme, isn't it?
It is, yes.
Yeah, and that's now got planning permission.
It has, yeah.
And then to the east of the scheme, that's the application for Keeper's Farm.
Yeah.
That hasn't been determined yet,
No.
correct? And that's one of the other reserve allocated sites in the neighbourhood plan, correct?
Yes.
Yeah, although I think it goes slightly wider than the allocation, but leave that aside for now. We've then got other applications just to look at. If you look at on the
western side of the appeal site, on the other side of Lubborsthorpe Road, the purple marking, that's the housing and other built development associated with the Leicester Lions Rugby Club, isn't it?
Yes.
Yeah, and that was obviously, that was in the Green Wedge, wasn't it?
It was.
Still is, I think, in the Green Wedge.
Yeah, if I had context to the application, members did, I think, officers recommended refusal, and that was no return by members.
They did. And I mean, officers recommended refusal on the basis of impact on the Green Wedge, didn't they, partly?
Yes.
Yeah. And obviously that's in that, I mean, that sits, that site, doesn't it, in what's referred to as Parcel A in the Green Wedge assessment. Correct. Yeah. Which is that narrowest area of separation between Whetstone and Blaby, correct?
Correct.
Yeah, okay. Thank you. Now, on the other planning permissions that are shown on here, we can see there's one marked 220606 full.
Yes.
I mean, again, that is in Parcel A, isn't it? That narrow parcel.
Yeah.
Yeah. And there are some extracts about that set out. If you go on to a couple of pages on, 220606. That was a supported housing scheme, wasn't it? And it was granted even though it was recognised there'd be impact on the Green Wedge.
It was. The acceptable impacts are. Yeah.
It was, sorry?
There are, yeah, there are acceptable impacts to that Green Wedge.
Yeah, okay. Yeah. And then if you look at, if you look above to the sort of north east of Blaby itself, 240439, that's Glenparva, isn't it?
That's the Glenparva site, yeah.
So we've discussed Glenparva. Thank you. Then there are two other things that are shown on the plan. You can see there's an application 1804666 full. That was in Lubborsthorpe. And then there's one up in the northwest corner, 2114974, Abbey Farm. And again, I mean, the basic point is they're all grants in the Green Wedge, aren't they?
They are,
yeah.
Yes.
And then there's also a yellow scheme marked inset into Kirkby Muxlow on the top, and that's, I think, an allocation, isn't it, in the 2019 plan? You see the key, it says policy SA2C, land at Ratby Lane, Desford Road, and that's in the Green Wedge as well.
Yes.
Yeah. So, I mean, what these all show, don't they, is that they show what we've already agreed, really, don't they, that the policy does allow balance to be undertaken.
They do, and indeed, a balance has to be taken, yes.
Yeah. Okay. Now that takes us to Mr. Custon's rebuttal, please, which you touched on in evidence in chief. And if you go to his proof, his rebuttal at paragraphs 2.4 to 2.6, he explains, doesn't he, there, and this is what you were addressing in evidence in chief, that there is an email that we've put into this rebuttal which explains that the council, as part of its preparation for its Regulation 19 publication, is considering the allocation of a site to the south of the appeal site, correct?
Correct, yeah.
Yeah. And if you go to his Appendix 2, that marks on, doesn't it, with a kind of, there's an orange and yellow and blue lines for the different land ownerships. But all of those lines together, they constitute the area which the council is considering allocation in its Regulation 19 plan. Is that correct?
Yeah.
Yeah. So, first of all, I mean, you're not disputing the facts, are you, that this is something that's under consideration?
It is in consideration, yeah.
Yeah, okay. Obviously, it hasn't reached Regulation 19 stage. In your evidence in chief, you said you would give it very limited weight, given the stage it's reached, but not no weight, correct?
Correct, yeah.
Yeah, okay. And it shows us again, doesn't it, that housing need is such that the council is giving consideration to the allocation of a large area of land that sits between the three settlements we're concerned with.
It does show that, yes.
Yeah. Now, in relation to that,
you mentioned Mr. Collins's evidence in your evidence in chief about there being a fundamental tipping point in relation to the green wedge here.
Yes.
I mean, if the inspector's going to consider that point, then does the inspector also have to give some consideration, at least, to what we see here?
I believe that our weight is so limited that I don't think there should be. No.
Well, what we do know is that any possible fundamental tipping point hasn't deterred the council, has it, from considering that site for allocation?
It hasn't.
No, okay. Right, can we move to recreational loss then, please? So we're dealing with reason for refusal 2, and as we discussed, I think, maybe I discussed with other witnesses, it cites paragraph 103 of the MPPF, but it means paragraph 104, correct?
Correct,
Yeah.
yes.
And in relation to policy CS15, could we look at your proof of evidence, please, at paragraph 3.2? You say in 3.2 there are recognised differences between CS15 and paragraph 104 of the MPPF, correct?
Yes, correct.
Now, there's a very fundamental difference, isn't there, between them, which is agreed in the Statement of Common Ground, paragraph 8.8, which is that CS15 requires multiple criteria to be met rather than just one of those criteria.
Yeah.
And that's why we agree, don't we, in the Statement of Common Ground, that very limited weight is to be afforded to policy CS15, correct?
Correct, yeah.
Right. So if there is any conflict with CS15, which is what's alleged in reason for refusal 2, the weight that one would give to that conflict would be very limited as well, then, would it? Given its policy, that's a very limited weight.
Yes.
Yes. And it's out of date, of course, because not only is it deemed out of date by paragraph 11D, because you have no 5-year land supply, but it's inconsistent with the MPPF, and that's one of the biggest drivers of reduced weight development plan policies, isn't it?
Yes.
Yeah.
Yeah.
Okay. Now, we know that we can, in terms of paragraph 104, as you were said in evidence in chief, we can meet any of those 3 criteria and be consistent with the policy. Correct?
Correct.
And we know that the first criteria is the one I've already discussed with Mr. Wright.
Yes,
so I'm not going to ask you
Thanks.
anything about that. In your proof at 3.8, you say there are no references in either CS15 or the MPPF, paragraph 104, that there should be differentiation between the use, quality, etc. of sport provision. Now, when you wrote that, you were probably relying, weren't you, on Mr. Wright's evidence about quality?
Yeah, there would be that. Yeah.
You would.
Yeah.
I discussed that at length with him yesterday. Presumably you defer to any answers he gave about quality as a relevant consideration under 104A.
Yes.
Yes. Now, under 104B, which you are dealing with, that says the loss resulting from the proposed development would be replaced by equivalent or better provision in terms of quantity and quality in a suitable location. So under this criterion, there is absolutely no doubt whatsoever, is there, that quality is relevant because the MPPF expressly says so.
Yeah, we have to say that, yes.
Yeah, okay. Now, in terms of how we consider that issue, in relation to the quality of the existing golf course, yeah, the
Yes.
existing provision,
Yeah.
I put it yesterday to Mr. Wright that what we have before this inquiry is a very detailed account of quality in Mr. Smith's proof for the appellant, yes,
Yeah.
and very limited information on quality in Mr. Wright's proof because he took the view it wasn't relevant. Yeah. Now, in re-examination, it was said, I think, that there is also, of course, the Gulf Needs Assessment at CD 8.6. And I wonder, can we just look at one thing in relation to that, please? So CD 8.6. Because I think what was said in re-examination was that there's a whole section or chapter that deals with the issue of quality in this document. And I wanted to just look at that with you. I don't know whether this is a matter that you have relied on, because obviously the one thing that you do have to consider, don't you, is quality of the existing situation. That's part of 104B.
Yes.
So there is a section, as I think was said, in relation to the issue of quality. So can you go to electronic page 21? So there's a heading quality, and it said judging the condition of Gulf facilities can be difficult because there's no rankings to inform the position. And then generally, the better the course quality, higher the joining fees, etc. And it also says quality can be subjective. Now, if you then look down to bottom of page electronic 22, there's the detailed evidence on quality. If you look at 2.66, for a full quality analysis in relation to playing facilities and ancillary provision, see table 2.9. Yeah. And then what table 2.9 does is it sets out a quality assessment of every single golf facility in the catchment area, correct?
Correct.
Yeah. And so insofar as we're concerned under 104B with the quality of Blaby, if you go to the bottom of page 24, you'll see there's not item 16, Blaby Golf Centre, and there's a handful of short paragraphs dealing with it. So that's the information, isn't it, that there is on the quality of Blaby in that assessment?
In that table, yeah.
Yeah. Okay, thank you. Now, in relation to this, we also need to talk about the Davidson's permission, which I've discussed again extensively with Mr. Wright, and we agreed earlier that obviously permission's now being granted. I mean, you heard the information yesterday, didn't you, about the potential impacts that would have on the course and the works that might have to be done.
Yes.
Again, are you deferring to Mr. Wright's evidence on that?
I would be, yes.
Yeah. Okay. Now, the only thing I then need to ask you in the light of that, I think, about these matters is really about your proof at 3.9. So 3.9. Well, actually, before we do that, could we just look at your 3.17? I was asking you for a moment ago about where we find the information about the quality of Blaby as an existing facility, and we've looked at the sources now. We know what there is. But in your proof, correct me if I'm wrong, I think the paragraph where you address this most directly is in 3.17, where you quote from the England Golf letter. You say it's an excellent facility based on what they've said.
Yes.
Yeah. You don't carry out any more detailed quality analysis, do you?
I'm not required to do that, no.
No, you don't do that, no. Okay, now if we then go to the paragraph I asked you to go to, which is 3.9 of your proof, you say the facility was originally designed to be accessible for all ages and abilities. Through developing the site further, it has continued to increase the facilities to enable this to happen, which has resulted in year-on-year increases in footfall and turnover. Now, I just wanted to understand, what the source of your information is in relation to that. So you say it was originally designed to be accessible to all ages and abilities. Where did you get that information from? Have you looked back at the 1990 planning applications? Or is this talking to the golf tenant?
I believe this is a range of sources. I can't, unfortunately, implicitly confirm where that information has been gleaned from. But I've just read it as
right, so you've got no evidence, or no further evidence to support that view?
Nothing written down, no.
That it was originally designed for that. Okay, that's fine, I'll leave that topic. You then say in the same paragraph, it's resulted in year-on-year increases in footfall and turnover. Now, I assume that in relation to footfall, what you're referring to there is the evidence that's in the golf assessment. Do you remember that refers to the increase between, I think it's between 23 and 24, correct?
Yes, that's right, yes.
That's what you were relying on, yes. You haven't discussed rounds and footfall yourself with the golf tenant?
No.
No. And you hadn't seen, had you, when you wrote your proof, I don't know, the more specific information that's included in Councillor Hartshorn's evidence?
No, I wasn't aware of
you hadn't seen that. Okay, so that's fine in relation to footfall, and I discussed that yesterday with Mr. Wright, so I'm not going to go back over that. But you say increase in footfall and turnover. Now, can I just ask you about that? And I think there's a kind of quick way through this. I think you've just made the assumption, haven't you, that if there are more rounds of golf being played, that there'll be more turnover. Yes. Logical, I suppose.
It seems to be a logical.
Yeah, logical. I'm not going to argue with you. It sounds logical. But obviously, you haven't seen the accounts, have you, of the operator?
No.
And I mean, one of the points that's made in Mr. Smith's statement, CD 5.1.9, I don't think we need to go to it, is that there has been a high increase in recent years on the costs of operating a golf centre because of inflation, fuel inflation, etc. I mean, so even if it's right there's an increase in turnover, we don't know what that means in terms of profit and loss, do we?
No.
No. Okay, thank you. So just coming then to paragraph 104B and understanding how we apply that policy, it does not require, does it, equivalent or improved provision in terms of both quantity and quality. So you can have less open space provided, but if it's a higher quality, it can meet the test.
Provided that, yeah, it's done.
Yeah.
Yes.
Right. So when you look at 104B, I mean, maybe we should just let's have a look, please, at CD 10.1. which is a case that was mentioned in your evidence in chief. CD 10.1, so that's the appeal. Sorry, that's the appeal decision. I think the case that was mentioned was the High Court case that's referred to in this. So this is an appeal decision at Gately Golf Club. Do you see that?
Yes, I see that.
Yeah. And if you go to paragraph 18, please. You'll see the inspector says the difference between the parties relates to paragraph 104B regarding whether the appeal scheme, together with the suggested package of measures, represent equivalent or better provision in terms of quantity and quality in a suitable location. And then it said case law has determined that equivalent or better provision referred to in paragraph 104B is more open than the council suggests and does not require a like-for-like replacement, both in terms of sporting activities, i.e. golf for golf, or the amount of land. Paragraph 104C is not envisaged in this appeal. The appeal scheme is not predominantly for alternative sport and recreational provision. Now, on B, the position then is that to meet B, it doesn't have to be golf for golf.
No.
And it doesn't have to offer the same amount of land as there was prior.
No.
Okay. It's a broader judgment.
Very much so, yeah.
Broader judgment. Now, the appeal scheme, as we've already discussed, will deliver 10.5 hectares roughly of public open space and green infrastructure, correct?
Correct.
And the largest part of that is on the eastern side of the scheme.
Correct.
And you'll have seen, we can probably discuss it at the condition session, that Mr. Holliday has suggested a condition, additional condition, which will lock in that larger public open space area there.
Thank you, yeah.
Okay, and that's agreed, isn't it?
Yeah.
Now, the 10.5 hectares of open space, green infrastructure, etc., that we're providing, that will provide, as we discussed earlier, an increase in the public open space, formal and informal, within the site, correct?
Correct.
And it also provides another sports facility, the football pitch, correct?
Correct.
As well as a community orchard and a number of natural green spaces and walkable routes, correct?
Correct, yeah.
So while the area of open space is obviously going to be smaller post-permission, the area of public open space will be larger, yes?
Yes.
And the fact that it's a smaller amount of space is not determinative, is it?
No.
No. So we must consider both quantity and quality, correct?
Yeah.
And we've talked, haven't we, about the existing quality already, because that's really where you rely on the evidence of Mr. Wright.
Yeah, Mr. Wright.
Okay. Now, can I then ask you to go to CD 11.1, please? So this is one of the High Court judgments that I think has been referred to a couple of times now. And you'll see, if you go to paragraph 27, well actually, I mean, maybe start at 23 so we understand the context. So 23, electronic page 9. The argument was there'd been a misinterpretation of paragraph 74 of the framework, which is now 104, by advising that quantitative loss of open space may be outweighed by qualitative improvements. So that was the argument. We know that's not right now, of course, and you'll see at 27, the court says a submission was made to the same effect in Turner, and that was rejected by the judge there. And you'll see in the quotation, any development to provide open space which is at least equivalent to that lost both in quantity and quality. It's not a correct interpretation to allow a smaller quantity because of enhanced quality. We've agreed that's the position, yeah. And then I think at the bottom of that quotation on that page, I think that there is an over-mechanistic approach. I think that's an over-mechanistic approach. And onto the next page, but it is you see that it says, but it is in my view appropriate in a case such as this to consider the reality, which is that the existing spaces were largely unused by the general public. So one of the things that's relevant under 104B is the extent to which the space, as it currently exists, is actually used by the public, correct?
According to this judgment, yes.
Yes, according to this judgment. So, in terms of public accessibility, obviously at the moment the golf course is a private facility that you have to pay to use, correct?
Yes.
The footpath through the site is the only public accessibility, general public accessibility through the site at the moment, correct?
That's what, yeah.
And the survey evidence that you touched on in your evidence in chief shows, doesn't it, that the footpath through the appeal site is not very much used compared to the other footpaths that were surveyed, correct?
No, I do that once, yeah.
And I think you agreed with my learned friend that the reason for that was likely to be that people don't want to be hit by a golf ball, correct?
Correct.
Seems a reasonable assumption, I think you said, which is right. It's relevant for us to consider then under 104B, isn't it, the extent to which the footpath, the only publicly accessible open space, is used or not used. That's a relevant consideration.
It is, yeah.
Yeah, okay. Good. Now, in terms of the provision of public open space that we are providing with the scheme, could I ask you to go to the illustrative master plan at CD 2.19? Now, all of the public open space that's provided as part of the scheme
is the subject of a condition, as we agreed, correct?
Correct.
Yeah. There's also the condition that's been additionally volunteered through Mr. Holliday's evidence that secures the eastern section of the site to only be delivered as public open space, correct?
Correct.
Yeah. And one can see from here that one's got an extensive area of public open space with new planting, etc., on that eastern side. You can see the football pitch, yeah. And then there are also corridors of green space and open space along the edges of the development and through the development, correct?
Correct.
Yeah. Thank you. And landscaping would be something that has to be approved through the conditions and the reserved matters, correct?
It would be, yes.
Yeah. Okay. Good. You talked about the other obligations that we are offering for off-site provision, but first of all, there are obligations, aren't there, in the Section 106 for the on-site football pitch, the on-site play areas, and the on-site public open space. Those are all matters also dealt with in the Section 106, aren't they?
They are, the policy compliant, yes.
Yeah. Well, the policy compliant, but I mean, my point is that you've got control both via conditions and Section 106 over the public open space delivery, haven't you?
We have.
Yeah. Okay. Now, in paragraph 3.13 of your proof, you say, turning to the 11 by 11 pitch, whilst a sizable contribution to the needs does lack the very detail to ensure this is delivered. Well, I mean, we can withdraw that point, can't we, after where we've got to now? That's all subject to conditions 106. It can all be conditioned, correct?
Yes.
Yeah. Okay. And you say there is little information about how this feature will be used, e.g. informally or for formal matches. So just pause there. I mean, again, there is provision, isn't there, for an on-site public open space area scheme in the Section 106 and in relation to the on-site football pitch and play. But just for a moment, say you're right, that it's not, you can't control whether it's informal or formal. Whether it's informal or formal, it still provides sports provision, doesn't it?
It does. I guess the point we're trying to make with this is that it just lacks that specific detail to ensure that it lives up to its expectations. I mean, having 11 by pitch is great, but if it's not well maintained and it's just an antisocial behaviour ridden site, that kind of issue, well, I guess that's what I'm just trying to draw out with that point, is that it needs the detail to show that it's going to be worth its salt.
We've agreed it's all of this is subject to control through conditions in the 106.
But yeah, I guess I just control if it has to be sure that we actually get what's actually put forward. Again, that's my only concern with that.
Right. I mean, similarly, if you look at your 3.10 on the same page, at the last three lines, you say the proposals for the open space requirements could be changed, and the lack of commitment to firming up these details from the outset is worth mentioning. But we're entitled to make an outline planning application.
We, of course.
Yes.
Yes.
You've got control through reserved matters.
Yeah.
You've got control through conditions.
But then my argument again is if this stuff is so important, then it should be put forward right at the outset. If you're that committed to a scheme of this high achieved, then it should be put on plan.
Let me put it to you this way. Is there any way in an outline planning application that we could commit any further to the delivery than we already have through conditions 106?
A landscaping scheme? You can apply an outline and approve a landscaping plan or further details through.
And was that ever asked for in the course of the application that sat with the council?
Unfortunately, I can't confirm or deny.
No, you don't know.
No.
But, I mean, we have to have this... I do need to sort of pin you down a little bit on this, really, because could we look perhaps at the Section 106? I know we've got a session coming up on this, but CD 5.5a, I think, is probably where we need to go. Yeah. I mean, so yeah, CD 5.5a, and maybe if you could go to electronic page 17.
And I mean, I don't want to kind of go back over this, but you did agree with me earlier, didn't you, that we've got a level of control which is at least equal in terms of delivery of our public open space areas to that at Glen Parva. Same conditions for landscape, conditions for reserve matters, correct?
Yeah, correct.
Yeah, correct. Now, we've also got the 106 here, so just some of the examples of this. I'm not going to go through it all, but you'll see halfway down the page there's a definition of the on-site football pitch. It means a football pitch to be provided within the on-site public open space area. Precise location and extent of which is to be approved by the council, so that's a matter for the council to approve, as part of the reserve matters approval, and also there's a requirement for an on-site public open space area scheme to be submitted. So those are some of the controls that there would be, correct?
Correct, yeah.
Right. Then the same you can say for on-site play areas. There's a similar set of provisions, yeah?
Yeah.
Then if you go down to the next page, page 18, there's on-site public open space area. Yeah. And again, subject to approval through reserve matters, subject to approval through the open space scheme. And then if you go down to on-site public open space area scheme, a scheme detailing the location, size, materials, permanent availability, specifying details for future management and maintenance, plans, drawings, specs, etc. We've got to submit all of that to get approved, haven't we?
Yes, as I say, and this is not a point I wanted, diarrhea over.
So,
It's I just wanted to, again, expressly say that if you are saying how you're going to be proposing all this stuff, some sort of commitment of the land, and now, an indicative plan may have been.
Well, we have got an indicative plan. We've got the.
So you just went with more concrete, I guess. I guess my fear as an officer looking at reserve matters is making sure that what is built matches what's agreed at outline, I suppose.
Well, come on, we've got an illustrative master plan, yeah? Right? Got that? We've got all of these conditions and schemes that have to be imposed. And the 106 is agreed with the council, isn't it?
Yeah.
Yeah. And the conditions are agreed with the council. Yeah. Yeah. So, I mean, just want to close this off. I mean, this point, I know you made it in your proof, and I know you wanted to defend it, but this point about there not being a sufficient level of control over what's delivered, it's a bad point, isn't it? Time to pull it back and withdraw it now. What do you say?
I just think it's a point worth mentioning. I think I made that clear. It's just a point to reference. It's not a reason for refusal. I've not left it as an important issue, but I just think it shows commitment, having something else other than just illustrative plans or something as Section 106 agreement, which is legal. I don't dispute the weight of a Section 106 agreement. I would just like something else to bolster the arguments. But as I say,
well, I think the inspector probably has my point in relation to this. Now I'll move on. Now, one of the things I want to just pick up with you is that this pitch has been offered, hasn't it, in response to the consultation response of officers in the health and leisure team.
yes.
Could we look again at their response, please, which you looked at in evidence in chief, and that's CD 3.12. And you'll see this is consultation response for playing pitch provision for the sport and physical activity team at BDC. And they refer, don't they, in the first paragraph to Blaby District Council's playing pitch strategy.
Yes.
Yeah, so that's a strategy that you apply to all playing pitch considerations in planning, is that right?
Yes.
And you'll see there's a reference to use of the PPS. There's a heading, and it talks about important that you have regard to the PPS as it's called. And then if you go to electronic page 3, you'll see it says suggested projects football. And it says when looking at data derived from the PPC for the development, the highest demand can be seen for youth 11 by 11 provision. Youth pitches have been highlighted as insufficient in the Blaby East area for now and in the future, as outlined in Table 2.4. Currently they are overused by 1.5 match equivalent sessions, and this will only be further exacerbated by future developments. which has been noted as high demand. So I think there was a point made in your evidence in chief about this being mere mitigation, but there's a recognition here, there's an pre-existing need issue in relation to football pitches of this size, correct?
Yes.
Yeah. Thank you. And then if you go down to the next page, electronic page 4, towards the bottom of the page, before the heading Rugby Union, the last 3 lines of the paragraph above that, therefore, further grass football pitch provision for youth football, 9v9 or 11v11, is required to meet the demand of this development. The developer has suggested that a pitch is provided on site, which would meet the demand identified in the PPS document. So that's a need that's related to the development, but also a need relevant to what's identified in the PPS document, correct?
Yes.
Yeah. And then if you go to page, electronic page, still the bottom of electronic page 5, you'll see there's a reference that there's a large demand for artificial grass pitches. You see that said?
Yes, I can see that, yeah.
And then if you go to the next, actually no, it's electronic page 7, please. Well, at the bottom of page 6, it says summary of suggestions. I think you went to this in chief. So from the data, the 4 main suggestions collated are, and one is a 9v9 or 11v11 youth pitch provided on the development site, and that's what we have sought to provide, correct?
Yes.
And that's secured via the Section 106 agreement.
Yes.
Yeah. Okay. Now, it also says, do you see third bullet point down, contribution towards ancillary facilities at Oakfield Park to support the width pitch provision. Okay. Now, the reason I go to that is that if you look at your proof again at 3.13, you say it is not proposed in the description of the development. Well, you mean the football pitch?
Yes.
Yeah. But I mean, that doesn't matter, does it? Because it's part of public open space, which is described in the description of development.
I guess for me, something like that, if I was validating the application, I would consider to put that in, because I think it's quite a sizable development.
Yeah. But it is
open space. I guess, yeah.
It is.
Yeah.
It is public open space, though, isn't it?
It is, but something of that
Right.
specific to me,
Okay.
I would probably put that in the description.
I don't think we're going to waste too much time on that technicality. We've seen how it's secured through the conditions of the 106, so I don't think we need to spend time on that. Now, you then say it appears merely to be incorporated as an additional but informal sports feature for casual play. Well, if so, it's still making sports provision, isn't it?
It is.
Yeah.
Yeah.
And then it says, without full consideration of how it will be used. Well, again, back to the section 106, there's a scheme that has to be submitted, correct?
Yeah.
Yeah. And then, without the inclusion of changing facilities or car parking, for example, there are reservations that what's proposed will not actually come to fruition. Yeah. Now, I mean, pausing there, it's secured that we have to provide this through the 106, correct?
Yes.
Yeah. Now, in terms of no changing facilities, if you go back to what we were just looking at in the response, the ask by your colleagues was for a contribution towards ancillary facilities at Oakfield to support with the pitch improvement. Yes, that's one of their asks.
Yes.
Yeah. Now, if you then go back to the section 106 that we were looking at, please, so that's CD 5.5a. And I'd like you to go, please, in CD 5.5a to, I think it's page 24. So I think it's electronic 24. Let's have a look. Yes, it is, electronic 24. Bottom of the page, and you'll see at the bottom of electronic page 24, I think it's also numbered page 24, there's a sports facilities contribution. Do you see that? Yeah.
Yeah.
Yeah. And that sets out, doesn't it, a sum of 260 odd £1,000 towards various things, including 3G pitch elsewhere, Oakfield Park, improvement to Northfield Park to support the provision of overplay and cricket provision in Blaby East. So those are all things that were also asked for, and they're also being provided, aren't they, in relation to the scheme. They're all contributions you say are still compliant, yes?
Yes.
Yeah, okay. Okay, now, you accept, I think, do you, because there was a point raised about this in the statement of case by the council, but it hasn't been raised in your proof. In making the offer we have, both for the on-site and off-site contributions and provision, they were made in the light of our having had this consultation response from your colleagues.
Yes.
Yeah, okay, thank you. Now, 3.15 of your proof, please. You say the proposed development is being built on a site where the existing golf course has specific characteristics and would dismantle a proven mechanism for introducing and developing new golfers, hindering the long-term viability of sport in the region. Those words are in quotation marks. Do you know where they're from?
I believe they're from the Golf Needs Assessment.
I think they're from the officer report, actually.
Okay. I believe that was
from your colleagues.
Yeah.
Okay. All right. 3.9 of your proof, please. Now you've got two paragraph 3.9s. So if you just go to 3.8, there's first paragraph 3.9, and then the second one over the page is the objection from England Golf to the application has given the council further evidence that losing the facility will cause issues. Just on that, I touched on some of this yesterday, but as you're the planning witness, they're not a statutory consultee, are they, Sporting?
I believe they're not, no.
No, sorry, not Sport England. England Golf, not a statutory
Golf,
consultee. Sport England are a statutory consultee on some applications, correct? Although there are proposals, aren't there, by the government to remove them as
They
consultee?
are indeed, yes.
Yeah, okay. Right, can we then turn to the planning balance, please? And this is the final substantive topic, and the various things we have to go through. Your proof, first of all, paragraph 4.5. Again, I'm afraid you've got two 4.5s. If you go to the very last page, it's the second paragraph, 4.5. You see it says, this is not to suggest the council view that these matters of limited weight are not important, but it does show that when considering all the relevant matters, the council have made a very balanced decision and determined that planning permission should be refused using a careful planning judgment. So you describe it as a very balanced decision. I just want to understand what you mean by that. I mean, do you mean that the competing factors, the harms on one side and the benefits, are quite closely matched, so that you had to do a very careful balancing exercise?
I believe that the arguments on both sides, there are similarities in terms of how you assess them, but ultimately the negative impacts of the development still significantly and demonstrably outweigh the benefits.
Yeah, well, I thought you would try and I thought you would say that, but we're agreed, aren't we, that tilted balance applies? You've established that in your evidence in chief. The test in the MPPF that then applies is that any adverse impacts of granting permission would have to significantly and demonstrably outweigh the benefits. Yeah. Otherwise, permission should be granted. Correct?
Correct. Yeah.
So we have to identify the harms and we have to identify the benefits. But the refusal of permission is only justified if those harms significantly outweigh the benefits. Correct?
Correct. Yeah.
Now, in your proof, please, and this is your written evidence to the appeal, I just want to look at your paragraph 5.1, if we could. The last 4 lines. It is therefore considered that the benefits that have been outlined, particularly the provision of housing in general and affordable housing, would not clearly outweigh the harm to the wedge and must be given substantial weight, and the other harm identified to prove the development. That is your overall conclusion as set out in your proof of evidence, isn't it?
It is.
It's wrong, isn't it?
Well, for a start, I do admit that I probably should have included the loss of the recreational facility within that, because I think we just mentioned the wedge.
It's wrong for a more fundamental reason, isn't it? Let's go and look at the MPPF, shall we? So that we've got it in front of us while we look at your evidence. CD 9.1 of the is the MPPF. And I'd like you to go to look at, obviously, paragraph 11D, which is page 6 of the document. It says, any adverse impacts of doing so would significantly and demonstrably outweigh the benefits. Yes, that's the test, correct?
That's the test, yeah.
So the framework asks, doesn't it, whether the harms outweigh the benefits. Yeah, not whether the benefits outweigh the harms, correct?
Mm-hmm.
Right. Secondly, it's not sufficient for the harms merely to outweigh the benefits. They have to significantly and demonstrably outweigh.
Yeah.
Now, just to look at your proof again, it is therefore considered the benefits that have been outlined, particularly the provision of housing in general and affordable housing, would not clearly outweigh the harm. You've applied the test the wrong way around, haven't you? You've asked the question of whether the benefits significantly and demonstrably outweigh the harms, not whether the harms significantly and demonstrably outweigh the benefits.
I have, however, I still think that the overall conclusion is justified. And if I can explain that, why that might be.
Go on.
Thank you. For me, it's a two-prong exercise. So ultimately, you have pros and you have cons.
Mm-hmm.
And as a result of that exercise, the cons have significantly and demonstrably outweighed the benefits. If that's been put in a odd fashion, I apologise, but that is the inspector how the decision has been.
Yeah. Well, I'll come to the balance itself in a moment, or probably after lunch now. But just to be clear, the way you have applied the test in your written evidence is fundamentally wrong, isn't it?
It would appear so.
Yeah. Now, before we leave the tilted balance, if you look back at the MPPF, after the bit that we've been considering about policies in this framework taken as a whole, it says having particular regard to a number of things, yes?
Yes.
So there are 4 things that you are then said that you must have particular regard to in applying the tilted balance, okay? The first one is directing development to sustainable locations. We're a tick on that one, correct?
Yeah.
The second one is securing well-designed places. We're also a tick on that one, aren't we? Because you're not raising any design reasons for refusal and not any design policies, correct?
Correct.
Right. Thirdly, providing affordable housing, which we are doing to a policy compliant level. So tick on that one as well.
Yeah.
Yeah, correct. Yeah. And then the other one that I haven't referred to is making effective use of land. Now that means, don't underdo the density, and there's no issue around that in this case, is there? You're not. Okay. Thank you. Now, can we then talk about the benefits for a moment? Your table that you've referred me to a number of times is on the penultimate page of your proof, and this sets out the pros and the cons of the scheme that you've taken into account in your balance, correct?
Correct.
And so we see the first 3 are the benefits that you've taken into account.
Yep.
Housing and affordable housing in the first one, Section 106 contributions and BNG in excess of 10%. And then the last 2 are the harms, the recreational facility and the green wedge, correct?
Correct.
Right. Mr. Cusson's proof, please, 9.12. So his main proof, paragraph 9.12. He sets out the descriptions of weight that he thinks that he wants to apply to the harms and the benefits. So substantial, significant, moderate and limited. Have you taken the same approach? Do you take the same approach of classification of weight?
Just familiarise myself.
Because, I mean, obviously, you've described, if you look at your table, you've got 2 significants, 1 moderate and 1 limited. So you seem to be matching his descriptors.
When I applied the weight, I did not look at that proof scale. I
No.
just applied my own knowledge.
No. But do you accept that substantial weight does sit generally above significant weight in the hierarchy?
In my experience of planning decisions, yes.
Yes. Okay. So if we then go to your table in your paragraph 4.5 or below your paragraph 4.5, you group together the provision of housing, don't you, both affordable and market, and you give it significant weight, correct?
Correct.
So you don't give it the highest level of weight that there could be. You don't give it substantial weight, you only give it significant weight.
Not according to the classification of this proof, no.
No. But, I mean, if you accept that substantial is above significant, given everything that we've gone through at the beginning of this cross-examination about the level of both ordinary and affordable housing need, shouldn't it be substantial weight to the affordable housing and the housing?
I'd have to say yes.
Yes. Well, I mean, I think that is the right answer for you, because, and I'll give the inspector the reference, I don't think we need to go to it, but Officer Report CD 4.1, page 73 electronically, they gave substantial weight to the matter. And in the Statement of Common Ground on Affordable Housing, CD 5.4, electronic page 12, para 8.10, again, it's agreed, and we looked at this earlier, substantial positive weight. So I think we can cross out significant and put substantial in that table.
If the
Okay,
consistency, I agree. 100%.
yeah, you agree, yes?
Yeah.
Yeah, thank you. Now, so that's the affordable housing. I think we've discussed that. Just on the weight that one gives to affordable housing, we've given it the highest level of weight, which I'm grateful for. One of the council's corporate objectives is to increase the supply of affordable housing, correct?
Correct.
Yeah, and that's CD 12.13. We don't need to look at it. Would you also agree with me that affordable housing, where it's provided and required to be provided by policy, is capturing a benefit? So it's not just providing mitigation for a scheme. The provision of affordable housing is a benefit, and that benefit's being captured and provided for by affordable housing. Do you agree with me on that?
Yes.
Yes, good, thank you. Right, biodiversity net gain, you say limited weight. The condition will require us to provide at least 10%, and we've set out in the Statement of Common Ground, haven't we, I think it's electronic page 33, that it's feasible for the site to achieve levels above 10%, correct?
Yeah.
Yeah. Again, when you have to provide biodiversity net gain, it is a gain, it's a positive, isn't it?
It is, but it's also a statutory requirement.
Yeah, but it's a statutory requirement to provide a benefit. Yes?
Yes.
Yeah, and we've demonstrated, haven't we, it's agreed in the Statement of Common Ground, that actually we can provide in excess of 10%, correct?
Yes.
Yeah. So on that basis, are you sticking with limited, or should we say moderate?
I'll be happy with moderate.
Moderate, okay, thank you. Then section 106, contributions for infrastructure, we've largely already talked about those. The one I haven't talked to you about is the golf facilities contribution. That's obviously argued in the council statement of case, and you've dealt with it in evidence in chief, not to be SIL compliant, correct?
Correct.
Now, Mr. Wright's evidence, and indeed I think we talked about this yesterday with him, was if, for example, Blaby were to close, because housing was going to be provided on the site, that a large number of people would move from Blaby to Enderby to play their golf.
Yeah.
Yeah? And I mean, I think similarly in reverse, if Enderby closed, they go to Blaby. So that means that there are potentially going to be more players playing at Enderby as a result of this planning permission being allowed, correct?
Well, displacement of golfers, yeah, they're going to want to find somewhere else.
Yeah. And indeed, we know, don't we, from the evidence that was given by Mr. Wright for the council, that there are, for example, some drainage issues at Enderby, which means that it can't be used at certain times of the year.
There are those quality issues.
Yeah. And we heard also, didn't we, that the operator had various plans to expand the facilities. Either, well, there's adventure golf that they wanted to do, and you talked about that in your evidence in chief, but they also want to put in, don't they, and they are putting in indoor golf. Yes.
There's plans for that, yeah.
Yeah. So, if this planning application would have the effect of increasing the use of Enderby, and there are existing issues at Enderby that require solving, like drainage or improving the facilities, there is a connection, isn't there, and a reasonably close connection between our contribution and this planning application.
There is, however, that has not been given in the agreement. It's just purely £100,000 for golf facilities.
Yeah,
we want that explicitly referenced to something. You know, the other Section 106 contributions have given it to something, a facility that already exists.
Right.
Just £100,000 for golf facilities does not give it that preciseness that would consider meet tests.
The money goes to the council, correct? If the inspector decides under the blue pencil test that it's a necessary obligation, the money goes to the council, correct?
It would do, yes.
Yeah. The council owns Enderby.
I believe that's true, yeah.
Yeah. If Enderby remains as a golf facility,
Yeah.
it has existing issues that will have a cost to be sorted out, like drainage, for example. Yes?
Yeah.
Right. That money could be used for that purpose.
It could, but again, that's not implicitly mentioned. That's partly.
But it's under the complete control of the council. I mean, it would have to be used to improve golf facilities.
Yeah.
So if the council did use it to improve the drainage at Enderby, or to part fund a crazy golf facility, or to part fund some other facility, that would be an acceptable use under the terms of the 106, wouldn't it?
If that in Section 106 clearly referenced that, I think that would be useful.
Yeah, okay, fine. Right, probably need to pause there. I don't think I've got a huge amount left, probably about 30 minutes max, but it's probably too long to go on, I would have thought, without having lunch.
Okay, well, excuse me, we'll adjourn there. Would or both parties like the normal hour for lunch, or you go shorter? Give me a time.
What's the time now?
It's coming up to 1:05 by the clock on there.
45 minutes.
Okay, so if we, well, we'll round out. We'll say resume at 10 to 2, needless to say, Mr. Glenn Baker, yeah. Thank you. Okay, so the inquiry's adjourned till 10 to 2. Thank you. Right, 10 to 2, so inquiry is resumed. Mr Morrissey.
Thank you, sir. Mr Baker-Adams, we were looking at your table on the penultimate page of your proof, and we've already discussed the first entry, which is homes. We've discussed BNG. We were talking about contributions, I think particularly around leisure. I just wanted to ask you one further thing about that, which is obviously on Section 106 contributions for infrastructure, you give those limited weight. So that would include the majority of the sports contributions that are in the Section 106, yes? But presumably it doesn't include the golf contribution because you've excluded that, haven't you, from your analysis?
Correct, yeah.
So if the inspector determined, contrary to your view, that the golf contribution was necessary and justified, I know you don't agree with that, but if the inspector agreed, would that then have to be added in as a benefit to your table, and would that take us under Section 106 contributions from limited to moderate?
Well, no doubt it's an added benefit. Obviously, more financial contributions towards the facility that is required.
So would you go to moderate then if we add that in? I know you don't actually agree that we should.
Yeah.
But if the inspector did, would that go to moderate?
Yes, I guess I would have.
Yeah. Okay. Thank you. Right now, before we turn to the harms in your table, I want to talk to you about some other benefits that are not in your table. And so, could we go to CD 5.3, please, which is the Statement of Common Ground, the main Statement of Common Ground. And I'd like to go to paragraph 8.24 on electronic page 26.
Yep.
So there's a list here, isn't there, of scheme benefits that we've agreed are benefits?
Yes.
Okay. So the first one is in your table, and the second one's in your table, so we don't need to worry about those. Now the third one, significant new areas of formal and informal public open space. That's not in your table, is it?
No, it's not.
No. Okay, well, we'll come to that in a moment. And then, obviously, it goes on that one, doesn't it, to say significant new areas of accessible formal and informal public open space through landscape planting, habitat creation, and the football pitch. Net gain is in your table, we've talked about that. Temporary economic benefits from construction through job creation and economic investment in infrastructure. There's no economic benefits in your table either, is there?
No, there isn't.
No. And then the last one is contributions to football, rugby, cricket and community facilities. We've talked about that one. That is in your table, yeah. So I want to talk about the other two because obviously, because you agreed, the council has agreed in the Statement of Common Ground that these are benefits of the scheme, we do need to include them in your table. So if we do that, the on-site, public open space, formal and informal, and the football pitch, what weight do we give that on your second column? And if we add a new row, which is for on-site, public open space, play, football pitch, etc., what weight do we give that? Moderate weight?
Yes.
Moderate weight. Okay, thank you. Now, economic benefits, as we said, not in your table. What I want to do is just first of all look at what the economic benefits are. So, could we go to Mr. Cusson's appendices, please? So that's in CD 14.8. And I'd like you to have a look, please, at his appendix 1, which is, as you will know, a statement of socio-economic benefits. And if you go to electronic page 7, that document. So first of all, deals with the temporary construction impact benefits, i.e. the jobs during the construction phase. And then he runs through the operational impact, so household spend of 2.3 million, increased council tax revenue, improved energy efficiency, supporting the climate change agenda, supporting employment, and then social value impact. Now, leave aside that last one, because I'm going to ask you some separate questions about that. Are all the others agreed by you as being economic benefits of the scheme?
I don't dispute the figures. No.
Right. Okay. Now, given that, okay, well, that's fine. So let's have a look at the last one, because you talked a little bit in your evidence in chief about the £1.8 million figure, first of all. Now, if you go to your proof, that's 3.12 of your proof. You refer to an assessment that we undertook, I think, at the planning application stage, which tried to look at what the economic benefit was of the creation of the public open space, etc., on the site. Yep. And I think you confirmed in evidence in chief that you don't dispute that figure either, do you?
No, we can't.
No, okay. Now, I wanted to just ask you, if you go in the same document we were just looking at, so the appendices to Mr. Cusson's proof, if you go to page, electronic page 9, you'll see electronic at page 9 that, sorry, just give me one moment. Yeah, actually, if you go to, can you go to electronic page 15, which is numbered page 9? I'm going to read this. And if you look at paragraph 4.16, you'll see that there's a different figure presented, which is the one we've just looked at in the earlier part of this report, which is 16.8 million as the estimated open space value. Now, I don't know whether you followed this through, but the difference between the 1.8 million that you refer to and the 16.8 million that's referred to here is the 1.8 million only looks at the benefit from users of the public open space coming from the appeal site itself, okay. Whereas this wider figure, the higher figure, comes from looking at those who live within 480 to 1,600 metres of the site. Yeah. Now again, that's obviously a higher figure based on a different catchment, and that's looking at the possibility, isn't it, that this public open space will be used by people other than those within the site, yes?
Yes.
Okay. Now that updated calculation, if you look at paragraph 4.14, it's explained that it's carried out in accordance with the field in trust guidance. You can see that's referred to in 4.14. And then in addition, further parts of the analysis are sort of set out before you get to that figure. So that higher figure, which you don't obviously directly mention in your proof, because fair enough, it only came with our proof, so you wouldn't have seen it, so that's fully understandable. But you don't dispute that figure either, do you, the higher figure based on the wider catchment?
I can't. The figures, the numbers seem well evidenced and justified. So,
yeah, okay, thank you. Now, if we then go back to your table, we're going to have to add another row for economic benefits. If we add up all of those economic benefits running across all of those matters, household spend of several million, income tax, the economic benefits from jobs in the short term, etc., and the social value impact, all of those many millions of pounds of economic benefit, what weight are you going to give to those, please, in the balance?
just said moderate.
Moderate. Okay, thank you. I'm going to say that. Now, in your proof at 3.12, having referred to the 1.8 million figure that we've discussed, you go on to say the actual figure is not in dispute, but there does need to be some recognition that there will be economic disadvantage with losing this facility for Blaby, i.e. the corresponding economic loss of Blaby. Now on that, it's correct, isn't it, that the conclusion that was reached on need by both Mr. Wright but also by our consultants Litchfield is that one of Enderby Golf Course and Blaby Golf Course are surplus to requirements.
Yes, that's the summary.
Now, that means, of course, that if Blaby is lost, you have the economic disadvantage of it going, correct?
Yeah.
If Enderby is to go, you lose the economic benefit of Enderby, correct?
Yeah.
Yeah. And that's true of jobs and general economic generation. Yeah. Okay. Thank you. Now, in terms of jobs on the site, could we look back to, please, the appendix that we were looking at to Mr. Cusson's proof, the socio-economic report that we were looking at a moment ago, and could you go to page, it's electronic page 16, numbered page 10. Now, obviously, we have, don't we? We have some figures for the number of users for playing 9-hole golf at both Enderby and Blaby. Yeah.
Yeah.
On jobs, we only have figures for Blaby. We don't have any figures for Enderby. But I just want to explore what the job figures are in relation to Blaby, because you'll see at 5.4 it said employment is already supported on site. Based on information provided by the business officer, growth officer at Blaby, the following jobs are supported on site. Now, there's a kind of a handful of jobs, isn't there, associated with some of the sort of non-golf related activities like paper boutique, etc. But the majority of the jobs on the economic growth officer's view come from the Congo golf course and the cafe, so the golf course and the cafe. I mean, do you know where the economic officer got these job figures from?
Not implicitly.
No. Well, you'll see that what's said in our report is that we obviously looked at the 2019 planning application that the golf club made at Blaby for a new fencing, and they stated in that document they had 3 full-time employees associated with the golf course. Now, that's information, it's the only information we actually have from the golf operator, although it's from 2019, about how many jobs are supported by the golf course, correct?
Yeah. Okay. Yeah.
Right, good. So that means, on that basis, up to 37 other jobs are apparently associated with the restaurant and cafe. Now, and that's 37 full-time jobs apparently, although we don't quite know whether that's correct or not. It may be part-time. But what's said by our consultant is, well, if you actually look at the data from the ONS, you wouldn't expect a cafe like this to have more than a total of 14 employees. You would not expect 37 in a cafe of this size. Again, I mean, I suspect it's a matter you can't help me on. You don't have any material either way on this, do you?
No, I guess that's one experience of being on the site. That number could well be in excess of that now, due to obviously the lapse of time since the application 19, wherever that was, approved to
You
now.
mean the golf?
Yeah, the golf.
The golf.
Increased
Yeah,
that because of that
so
popularity increase.
it could be higher. It could be higher than 3, but
Yeah.
but it's I mean, I guess we don't know, do we? Because we haven't got
that information. No.
we haven't got figures about use back in 2019 versus now, so we don't know. Okay, that's absolutely fine. Thank you. Now, of course, if you're taking into account these loss of jobs and loss of economic benefits from Blaby Golf Centre closing, we've already agreed one has to bear in mind the corresponding potential loss of Enderby. Yeah. But in addition, of course, we're proposing, aren't we, as part of our development, that we will recite the existing retail, leisure, sui generis uses, yes? Yeah. Or if those operators don't want to come in, then other operators could come in, yes? Yeah. And if you then go to paragraph 5.6 of this assessment that we've been looking at, you'll see it said, taking into account the information provided by the Business Growth Officer, up to 47 jobs supported on site. This appears to be very high compared to the ONS data. That's what we've just seen. If this figure is used instead, the total jobs on site are 24, and it says the figure would then increase if you had if you include the dance studio. So I think we've agreed you're not able to offer any information on that. But if you then go to paragraph 5.10, there is an assessment done of the likely jobs that would be brought by our recited, re-provided sui generis leisure retail, and that's 31 full-time jobs. Yeah, and you'd have to weigh that in the balance as well, wouldn't you?
Yes.
Okay, thank you. So, can we then come to the harms in your table, please? Which is effectively the loss of the recreational facility and the impact upon the Green Wedge. Now, on Green Wedge, you read the evidence of Mr. Collins, and you've agreed with that evidence, and you've relied on that evidence to form your view.
Correct.
And you've accorded it a moderate weight, correct?
Yes.
Thank you. Now, on the loss of the golf course, the loss of the recreational facility, you say that loss would be significant weight. Yeah. Now, that is the same level of weight that you originally gave to the provision of homes, correct?
Correct.
Albeit you've now agreed with me that we can push that up to substantial, correct?
Correct.
Right. But in a world when you were drafting this and you were according equal weight to the provision of homes and the loss of the golf facility, in terms of the competing policy objectives behind this at national planning policy stage, there is, as we agreed at the beginning of this cross-examination, a very strong impetus by the government to deliver more housing, correct?
Correct.
And there are targets set by government for Blaby and other councils in relation to the delivery of housing, correct?
Correct, yeah.
But there isn't, is there, any target set in national policy for the number of golf courses or seeking to increase the number of golf courses?
Do you think by government? No.
No. And indeed we know that generally, don't we, in Blaby, because this is the finding of Mr. Wright, Blaby is very well provided for by golf courses.
In terms of the sport itself, yes.
Yes. Thank you. And in relation to that, we also know, don't we, that he's agreed in his analysis of the need that either Blaby or Enderby is surplus to requirements.
One golf course is...
One
yeah.
golf is surplus. Now, if the inspector is considering whether it's right to attribute significant weight to the recreational facility, obviously that sits against, doesn't it, some of the benefits that you've agreed, i.e. the sports contribution, which is moderate, and the provision of public open space, play space on the site, which you also said is moderate. They would weigh against each other in quite a direct way, wouldn't they?
Yes.
Good. All right, thank you very much. Those are all my questions, Mr. Baker. Thank you very much.
Mr. Robson.
I'm going to do as I did yesterday with Mr. Wright and work back to front. Okay. You were taken to your concluding paragraph 5.1. If you pull that up,
yeah.
You recall those questions, and you said that you'd applied the test the wrong way around, and that the cons have significantly and demonstrably outweighed the benefits. You remember that answer?
Yes, I do.
Just so that we're left in no doubt, could you go to paragraph 4.3 of your proof, please?
Yeah.
And just read out the test that you've applied there.
A well-balanced exercise of planning judgment has been exercised, excuse the grammar, and it has been concluded that the harms significantly and demonstrably outweigh the benefits.
So then, with reference to the test in paragraph MPP, in paragraph 11 of the MPPF, that with the tilted balance, development should only be refused where harms significantly and demonstrably outweigh the benefits. Have you applied the correct test or not?
I believe I have.
There was a series, a line of a line of questions relating to 104B of the framework and the quality of the golf course, and then whether what's being provided is equivalent or better. Just 2 points. You were taken to your proof that references a year-on-year increase in footfall. Do you remember that?
I do, yeah.
It's paragraph 3.9 of your proof. And you were asked if you relied on the evidence in the golf needs assessment, to which you said yes, and that you hadn't discussed rounds and footfall with the tenant, to which you said no, and you hadn't seen at that point Councillor Hartshorn's evidence that he'd provided. You probably don't recall the full numbers from Councillor Hartshorn's evidence, but if we go to 5.6, page 56 and 57 of that document, CD 5.6, page 56 and 57.
Oh, yeah, sorry. Yeah.
Right. Firstly, this is an interested party comment to the inspector as part of this appeal. Should the inspector take it into account as a material consideration or not?
Yes, I believe they should.
I don't understand that there have been any dispute, certainly hasn't been put to any of the witnesses, of the figures contained in Councillor Hartshorn's evidence. And so if you look then at the projections that Councillor Hartshorn gives of an increase from 2025 of 28,000, 9-hole, 2,500 thereabouts, 18 through to 2026, 32,000 and forecast 27,000. In terms of your conclusion of a year-on-year increase in footfall, what does Councillor Hartshorn's evidence demonstrate?
That there is an increase.
This, I think, is just a point of clarity relating to the golf needs assessment. And you were referred back to Mr. Wright's evidence in re-examination yesterday that the golf needs assessment contains analysis of quality in various different locations. And the question was put to you that there's a handful of short paragraphs contained in table 2.9. Do you remember that?
Yes.
And you said yes in that table, which I take to be a reference to the short paragraphs in that table. Mr. Wright referred to other parts of the golf needs assessment that address quality. So, for example, if you have the golf needs assessment open, CD 8.3. Oh, I'm sorry, 8.6, yes. Thank you.
8.3 is open, yeah.
The paragraphs 2.61, 2.62, 2.63 including specifically with Blaby, and the references under the paragraph, under the table 2.9, with reference to how one looks at playability as part of quality.
Yeah.
What part should they play in the inspector's consideration of the council's evidence on quality? Are they relevant or irrelevant? Should he just confine himself to table 2.9? Well, perhaps let me phrase it another way. Table 2.9 was put to you and the handful of paragraphs. Should the inspector confine himself only to the paragraphs put to you, or should he take into account the whole of the golf needs assessment?
Sorry, the whole needs assessment.
You were asked a series of questions going back, I think, now to before the break, around application 0606. Do you remember that?
Where was that location, please? Do we have the...
The reference is in the appendices of Mr. Cusson's. Bear with me a moment.
Sorry.
So if you go to Mr. Cusson's appendices, page 78 on electronic version. Is the plan, and then 0606 is the land north side of Grove Road, Blaby. Are you there within the table? So if you scroll down to electronics, page 80.
Oh yes, I've got it.
And you were taken to that 0606 land north side of Grove Road Blaby case.
Yes.
And it was put to you that this was an example of the policy shows that allows a balance to be undertaken, with I think the point being that this council grants consent within the green wedge when the balance is undertaken. I just want to look at the detail of the committee report that's cited there. And the third paragraph down within the fourth column starts, your officers are of the opinion. You see that?
I can see that, yeah.
Your officers are of the opinion that the development of this relatively small scheme, pausing there, is this proposal a relatively small scheme or is this large?
No, it's priced.
Will not significantly harm the wider green wedge nor its primary function in this location as providing a green barrier that prevents the merging of the two settlements. You rely on the evidence of Mr. Collins. How does the conclusion in that office report compare with Mr. Collins's conclusion that the scheme would get to this fundamental tipping point of merging?
Yeah, there's a clear difference between those two.
The built form will not extend beyond the westernmost extent of the existing residential dwellings on the opposite side of Grove Road, and there is still retained undeveloped land leading up to the Blaby bypass. Again, just trying to compare it to the spatial situation here.
Yeah.
How does that compare?
Very differently. The developable land there will be a significant increase.
In addition, the scheme has been designed to provide a softer landscape that is less damaging to the character of the green wedge in this location. So in terms of assisting as a comparable exercise of how the council approaches the green wedge, is this of much assistance? Or?
I'd say it isn't, no.
CS17 and CS16 and whether it's stricter or not. Remember that, and Mr. Cusson's hierarchy, Cusson's rule on strictness.
I do remember the questions.
Remember that?
Yeah.
Right, do you have CS16 and CS17 open?
I can, just bear with me. Yes, they're open.
Right, let's just start with CS16, which is the policy we're concerned with, because I'll lead on this. We're not in an area of separation here, are we?
No.
The need to, within CS16, includes the balance that we've spent a lot of time on. The need to retain green wedges will be balanced against the need to provide new development in the most sustainable locations. See that?
I see that.
Right, now let's look at CS17. Do you have that open?
Yes, I've got that, yeah.
And that policy, in bold, tells us what the area of separations are designed to achieve, where they apply, and development's only allowed if it will not reduce the separation between the built-up areas of the settlements. Yeah. And then the final piece in bold on electronic page 2, the end of the policy on paper 83, is the need to retain areas of separation will be balanced against the need to provide new developments, including housing in the most sustainable locations. Is that the same or different to the balancing exercise you do under CS16? I'll keep CS17 open. I'll read you CS16. The need to retain green wedges will be balanced against the need to provide new developments, including housing in the most sustainable locations.
No, there is a difference there.
The need to retain areas of separation will be balanced against the need to provide new developments, including housing in the most sustainable locations. Is the difference the reference to green wedge and area of separation, or is there something else that's a difference? Or are you doing the same balance?
This is in addition to designate new areas of separation.
Will be balanced against the need to provide new development in the most sustainable locations. And then you're balancing the need to provide new development in the most sustainable locations under the green wedge policy as well. Is there a material difference or not? It may be that I have to use the words that barristers do, which say policy interpretation is a matter of law, and I can address this in submissions.
Yes.
Thank you. Probably a small point. You were asked with regard to landscape and visual effect, and the question was put, you agree that there's no unacceptable landscape and visual impact in 15 years, at the 15-year point. And the question was put that you accept that this is a big tick in the box, all of that development, and nonetheless this is a big tick in the box, this is a positive, to which you said yes. When you think about landscape policies, with particular reference to DM2, which is a landscape and visual policy, if a scheme does have an unacceptable landscape and visual impact at 15 years, would it conflict or not with DM2?
There would be a conflict, yes.
So when you talk about it being a big, the question was put in terms of it being a big positive, is not having an unacceptable landscape and visual impact a requirement of policy, or is it something else?
DM2 would need to be complied with as part of the application.
I think those are my questions, sir, in re-examination.
Thank you. You can step down now, thank you. Right, I think that draws us to the end of the sitting week. So we'll resume Tuesday next week at 9:30 with Mr. Holiday.
That's correct, sir. I guess I just wanted to raise in open whether do we think we're going to get further than Mr. Holiday on day one, because at the moment we've got Mr. Stacey down for day two. I think it probably would be quite difficult for him to get here on that first day, but I think I don't know. I mean, I can ask him, but he's at a hearing somewhere else. But he might be able to get here late afternoon. But it's a question of whether we think we might want him to try.
I mean, I certainly think we could do Mr. Holiday today.
Okay.
Probably with allowance for Mr. Stacey.
Well, I'll ask Mr. Stacey if he can attend, but he might not be able to. In which case, we'll have to do him on the Wednesday. But we'll have time to fit him in on the Wednesday as well, won't we?
Yes.
Yeah.
I'm happy to go towards 5:30 if that's going to help.
On the Wednesday, because I see on the
On
Tuesday.
the Tuesday.
Okay. Well, I'll ask him and see whether
So
he can get
if
here.
he does make the trouble of coming, as long as all parties are happy and the council can keep the premises open.
Because
until
I don't think you're
Sorry, I was just seeing if
no, thanks, Mr. Wilson.
location is too far away, whether we could patch
okay.
go hybrid for half an hour.
Okay.
But if we can't,
let me check with him, and I'll report back to you. And so we'll do what we can. We'll either try and slot him in on Tuesday, or we'll do it on Wednesday.
Yeah.
But on one of those days, we might have to sit a little bit later. But I think
that's fine.
Yeah. Okay, that's fine. Okay, we'll slot him in. That's fine. And then I'm assuming that we will carry on as per the timetable after that, so that on Wednesday we've got Mr. Smith on golf. We may have to also have Mr. Stacey, and then on the Thursday we've got planning, and we should on the estimates comfortably complete each of those.
Yes, I mean, I think it's 3 days next week.
Yeah, okay, fine. That's fine.
Okay.
Thank you.
Okay, that's fine. So just to confirm, partly for anyone listening on the virtual world, we'll do closings as planned then on, it's not on the timetable, I suppose. So we'll do closings virtually on Thursday the 28th, and in terms of sitting, that's the only thing that week. And we'll look at conditions and 106 also on the 28th, if time doesn't allow next week.
Yes, I mean, I guess we could plan on the basis that I think we'll probably finish planning comfortably on the Thursday, so we should probably think if we can do it on the Thursday afternoon before we finish.
I'd rather do it in person if possible.
Well, let's do it then. Yeah, let's do it then.
Okay, all right.
There's a travelling draft of conditions that are addressing the questions that you had. So
Right, okay, yeah, that's fine.
That's agreed between the parties.
Yeah.
Yeah.
I think it makes sense to do it while we're all here next Thursday, because we will have time, so let's try and do it.
It's easier than trying to deal with things in the virtual world.
Yeah, no, agreed.
Although I probably shouldn't say that.
No, no, that's great. Well, let's do that then. Let's aim to do it on the Thursday. Yeah.
Okay, all right, that's tidier. Okay, right. Mr. Robson, any housekeeping from you?
No, sir.
Okay, well, can I thank you all then, and wish you all safe onward journeys home, and good weekends. So we'll reconvene at 9:30 on Tuesday here, so thank you all.